on the podium a little bit longer. If you want to be heard on a bill, please sign up. We'll pick that up in just a minute. I'm going to ask Senator Watson to open us up in a word of prayer. What mic are you to?
Two. Thank you, Mr. Chairman. Let's go to prayer. Dear Lord, continue to look over us as we make the decisions for the citizens of the state of Georgia. Look over us in our travels and keep us safe, and especially with the impending weather. And in Christ's name I pray. Amen.
Thank you. Is Representative LaHood here? What about Representative Carpenter? Is he present? This might be. Okay. I was going to go to order for a second while I was waiting for the rest of the committee to get here, but okay, we'll go ahead and back to the agenda then. We'll start with House Bill 371, Representative Gunter. We heard this bill in committee on Monday. My understanding the bill hasn't changed since then. Is that correct?
That is correct, Mr. Chairman.
And so we're working off LC 280308S.
Correct.
And we don't have any sort of rules about strikes or second time being a charm or anything like that, you know. But we thought we'd give you one more shot to sell us on House Bill 371. If you can briefly tell us about the bill. I think some others have signed up to speak. I'll get the sign-up sheet.
Yep. Thank you. This is basically a codification of the uniform rules that the various courts use in conducting virtual hearings. It's a more efficient system, and that's basically what the bill does. It just puts the state stamp of approval on the use of those rules, and they've been in development over the last 15 years. So they've taken the best practices from around the state and compiled it into those rules. There are several folks, and here's the sign-up sheet. Just to save y'all time, I thought I'd go ahead and get started with those.
Before you do that, let me take some questions from the committee for you.
All right.
You have a question for him? Senator Hatchett.
Representative, if we codify this, this will save the state a lot of money, won't it?
That is correct. And one of the speakers from the Department of Corrections will tell you a little bit about that.
Okay, thank you.
It saves it not only at the state level, but also at the local level with the sheriffs and the county commissions.
Okay, thank you.
All right. Any other questions for the author of the bill? All right, we have several people signed up to speak on this. I'm going to go in order of how you signed up. First, we have Tane Kell.
Thank you, Mr. Chairman, members of the committee. I'm Tane Kell. I'm a Superior Court judge in Cobb County. If it's all right within the rules, I'll remove my mask so everybody can hear.
Yes, sir.
Thank you so much, sir. I wanted to speak on behalf of this bill. First of all, to answer some of the questions that came up in the committee meeting the other day, and also hopefully to reinforce some of the ideas about why this bill is a good bill. First of all, let me say this. The Confrontation Clause of the United States Constitution and the rulings of the U.S. Supreme Court have ensured the sanctity of the jury trial for criminal defendants. This rule is in no way attempting to abrogate that. In fact, the rule that this law would codify with respect to Superior Court, which is all of the felony cases that we would deal with, not only ensures that criminal trials would not be done by video hearing, but also that anything that's been deemed by the United States Supreme Court to be a critical phase of a criminal proceeding would not be done by video. So I just wanted to put that out there at the very beginning. The second thing I wanted to say is, after this bill, or a version of this bill, did not pass last year, we tried to work very closely, Department of Corrections and the Superior Court judges and judges at all levels of court, worked with the Georgia Association of Criminal Defense Lawyers, and I know Ms. Maisie Lancausi is here and probably signed up to speak about the bill too, but we worked with them to get language in the bill that both criminal defense attorneys and prosecutors, and also PAC, we worked with so that we could get language in there that everyone could be satisfied with. But let me get to one of the main questions that was asked the other day, and that was, why worry about codifying this? If it's something that we can currently do by rule, why worry about doing this? Well, it's real simple. We are a rulemaking body, or at least we have rulemaking authority under the statutes and laws and Constitution of Georgia. However, you are the lawmaking body. You are the legislature. And when we're dealing with things of statewide impact that affect all levels of courts, we feel like on two levels it's a good idea to allow you to have your say on this. Number one, because, and I'll just be honest with you, there will be a challenge to this rule at some point in time. We know that. Every rule that impacts the way that we do criminal and civil proceedings at some point in time is going to get challenged. And we would like the legislature to have put its stamp of approval, or to have said, yes, we looked at this and we think that this is an appropriate way to conduct some of these types of proceedings in both civil and criminal cases. And then secondly, it is something that, again, we believe is a huge both safety and cost saving measure, and I'll let Mr. Cooper from Department of Corrections speak a little bit more to that. But I can tell you from Cobb County's experience, because we participated in the pilot program of this video conferencing process well before COVID. That it was something that started about a year before COVID. We participated in it, and we have found that just the county's savings for the hearings that we're conducting with the Department of Corrections saves the county $2,000 per hearing. $2,000 per hearing. That doesn't count what the state saves. That's just what we in Cobb County save, because we don't have to send 2 deputies down to Jackson to pick up an inmate, to bring that inmate back to Cobb County, house them for however long that it takes, and send them back. And I will say one other thing, and I'm sure Mr. Cooper's going to touch on this too. From an inmate standpoint, if they are in, let's say, an educational program, they will potentially lose their spot in that program if they have to leave the institution where they are, spend 3, 4, 5 days traveling back and forth and being held by our county to have a hearing or another proceeding before they can get sent back. They can potentially lose their spot. They certainly may lose their bed. And again, I mean, it may be a small consideration, but for some people, having the same cellmate, having the same bed, those are all considerations that make a difference. But the main thing is this. We have found through COVID and throughout this period of time, we wouldn't have been able to do what we were called upon to do during this period of time without being able to use these processes. And as you may have heard in the Chief Justice's State of the Judiciary address, one of the things that he asked us to do at all levels of court is look at the efficiencies in the system that we have achieved during COVID, try to continue as much as we can to achieve those efficiencies and good practices that we've learned and carry them into the future. So if there are no questions, I know there are a number of other speakers, but I'd love to answer any questions that y'all have.
Any questions for Judge Kell? All right, thank you very much. Thanks for coming to share.
I think there was one.
Oh, sorry. Senator Hatchett.
I just have one quick question. I really like the intent of this bill, and I appreciate you coming to testify. The one question that I have, and I wanted to get your opinion on this,
yes,
is
sir.
In Section D.
Yes, sir.
Oh, wait, no, excuse me, 1 second.
Clerk of court. Oh, no.
No, Section C. Section C.
Yes, sir.
On line 27.
Let's see. Yes, sir. I think I'm on the right copy of the bill.
It says video conferencing shall not be authorized for use in any criminal trial where the accused guilt or innocence is to be determined unless, and then it says otherwise authorized by the court rule or agreed upon by the accused. I have a little bit of pause here because I feel like if it says it can't be used in a criminal trial unless it's authorized by court rule or agreed upon by the accused. And my understanding is the intent of this bill is to not allow the video conferencing to be used in a criminal trial, which is, of course, insinuating like a jury trial.
That's correct.
Would you have any, do you have any thoughts on that language?
I do. I think the language is good language, and I'll tell you why. One of the reasons that we want to wanted to incorporate the rules into the language of this statute rather than the way that it was originally presented in the bill last year, was we actually had the language from Rule 9.2, which is our Uniform Superior Court rule on criminal jury trials, incorporated in that statute. And one of the problems with that we heard from some of the other courts, particularly the appellate courts, was the United States Supreme Court's rulings on things like what constitutes a critical phase of a criminal trial changes. It changes with every new case that comes out on that. They add things to it. And we didn't want to include language that we would then have to come back to the legislature to change to include things that are critical phases. The Confrontation Clause of the United States Constitution, as it stands right now, the cases on that Confrontation Clause say that a criminal defendant has a right to be face-to-face with an accuser or a witness who is giving testimony against them. And only if and when that changed could I ever envision that something might change in a rule that would allow that particular thing to change. But that would take the United States Supreme Court coming back and saying, we were wrong on those cases that we decided on the Confrontation Clause previously, and we're going to change what the Constitution and the law means and says with respect to that. So we didn't want to put language in there that said it couldn't ever happen if the United States Supreme Court changes its mind about what's a critical phase or what's part of a criminal jury trials. But as it stands right now, we can't do it.
Mr. Chairman, can I follow up? Okay, so I guess my understanding now, when I'm reading this where it says video conference shall not be authorized for use in any criminal trial, this is, I guess the way I'm reading this, this is not authorizing the use of video conferencing to conduct an entire trial.
That is correct.
Okay.
If for example, though, let's say, I was going to say a motions hearing, but that would actually probably be a critical phase of the trial, so that wouldn't apply. But if there were some preliminary proceeding that could be conducted that's not part of a critical phase of a criminal jury trial, maybe it's procedural. Maybe we're going to have a meeting between the judge and the attorneys and the defendant to say, here's how we're going to conduct the upcoming jury trial in terms of seating, where we're going to put the jurors in the courtroom, which we're going to be doing a lot of coming up, trying to social distance and that sort of thing. But, this is a procedural hearing. We could potentially have that hearing as a part of, by video as a part of an upcoming criminal jury trial, because it doesn't involve anything that is critical to the jury trial itself. We're not going to be presenting evidence. We're not going to be having witnesses. We're not going to be determining things that would be part of the guilt or innocence phase of the trial. Does that answer the question? Okay.
Yes,
thank you.
Any other questions for Judge Kell? All right, thank you, Judge.
Mr. Chairman and members of the committee, thank you so much.
We have a couple other people signed up to speak. We'll now have Stan Cooper with the Department of Corrections.
Thank you, Mr. Chairman. May I remove my mask to be heard?
Yes, sir.
Thank you. Mr. Chairman and members of the committee, thank you for the opportunity to be heard. I'll be brief. If you recall, last year we were here and we testified this, as Judge Kell talked about, we had been about 10 months into this last year as far as the pilot stages with the Department of Corrections and the Superior Courts across the state. And at that time, all the state prisons have a set-aside hearing room equipped with all the necessary equipment to conduct the hearings. And when we were here last February, we had approximately 10 of the 49 judicial circuits utilizing that, operating at about 30 to 40 hearings per month at that time. You fast forward in March as we began the COVID era, and things really started picking up. And so in your packets that we gave you, I've given you some data that we've collected over time as talking about Senator Hatchett's question about savings. One of the things that happened, I asked our staff to put together two things from the inception on the first page. Of when we started the program with corrections. We started out in December in a pilot stage, and as of the 28th of last year, we've completed over 2,300, almost 2,400 hearings within the Department of Corrections. with that, based on the mileage alone, that corrections would be actually transporting people to facilities near counties where they would be going to court based on the court production order. We saved over 420,000 transport miles during that time. That is a huge amount. Almost 16,000 staff hours transporting those inmates to those locations for the different types of hearings. And as you'll see below that, there's the types of hearings that we had that was conducted during that. Now let's go to fast forward to last year and toward the end of the year. As we all know, the COVID period really hit hard, especially in the summer months, and we were really, the courts were shut down with the emergency order. They couldn't operate except using video type stuff, and so we had our peaks during those times. As you'll see, from July 1st of this past year to the end of December, there was over 1,800 hearings held just at the Department of Corrections. That's not counting all the local hearings that was conducted between the sheriff's offices, judges, DAs, and others, and public defenders during that time. Saved the state over 324,000 miles. This excludes what the county saved in their transports when they come to pick those inmates up. And so we are very much in favor of this bill, and you know, we feel really confident that this bill is a game changer, and it has been. It's exhibited now on the average. As of this month in March, we're scheduled to do 588 hearings versus the 30 or 40 we were doing this time last year, 588 hearings a month right now. And so we're excited about the opportunity to continue to build this. We think it's here to stay. The feedback from the participants in it, including the inmates, is very positive. And most of the judicial staff and others involved in this have expressed to us that this is something they want to do in the future. They don't ever want to go back to the other way. So with that, Mr. Chairman, I'll conclude and I'll take any questions.
Thank you, Mr. Cooper. Any questions for Mr. Cooper? Thank you very much.
Thank you, Mr. Chairman.
We have Terry Norris with the Georgia Sheriff's Association.
Yes, sir, Mr. Chairman. Terry Norris, Executive Director of the Sheriff's Association. In support of the bill, we have seen sheriffs throughout the state that have this video technology now, equipment technology now, save a lot of money. As you well know, we've talked to you many times about our inability to hire and retain qualified deputy sheriffs. So this has been a huge saving in terms of personnel, moving people not only from court production orders in the prison system, but also within the counties. So we urge you to seriously consider this bill and hopefully pass it out today. Any questions, sir?
Any questions, Mr. Norris? Senator Hatch, how many questions do you have on a bill you could have moved on Monday? Are you for the bill? Okay, today you are. Okay, go ahead and ask it.
I'll waive my question then. I'll waive my question.
No, go ahead and ask it. I don't want to cut you off. It's giving you a hard time.
Thank you, Mr. Chairman, as always. Thank you for coming to testify. How often do y'all use these virtual hearings?
I do not have those numbers. I don't really even know how many are using them, although I was talking to Stan Cooper earlier. In 42 of 49 circuits, 43 of 49 circuits, it's being used in some capacity. And now, of course, as you well know, circuits have anywhere from 1 to 10 counties or 9 counties. So it is used everywhere we have it available. And our intent is every sheriff is interested in doing this. Not every sheriff thus far has the resources to obtain the equipment. But I see it coming in the future, and I see any kind of grant opportunities that they're available to them. I see them using that as well as local money. We've joined the County Commissioners Association, which support the bill as well. It will be a huge tax savings for our local property taxpayers in the long run.
Thank you.
Yes, sir.
Any other questions for Mr. Norris? Thank you very much. Last speaker on this bill, Chris Arndt, District Attorney, and I did not get the circuit you're District Attorney of.
Can I take off my mask?
Yes, sir.
Lookout Mountain Judicial Circuit.
Lookout Mountain. I was trying to get
Northwest
the
Georgia.
Yes, sir.
We were one of those 10 circuits that jumped aboard early, and we started using this system both pre-pandemic and post-pandemic. I'll just give you a few examples of how we used it, and then I'll be happy to take any questions on some of the specifics. Before the pandemic, we were doing arraignments of folks in prison. We were handling probation revocations. A lot of times, someone that's on probation in our circuit may take off, go somewhere else, commit a crime, get sentenced to prison, and they've got a probation warrant outstanding with us. They just want to get it wrapped up and handled. So we were doing those. We've done pleas. All of my counties border another state. We've done pleas in other states' prison systems using the equipment from the Department of Corrections. We've done pleas with people in federal prison using this system. The system the Department of Corrections has is of a superior quality to anything I've seen from another state or from the federal government. It's real time, it's clear, you can hear what's almost like being literally in court when you're on that video system. During the pandemic, we've used it. Not only did we purchase for all of our courtrooms, but 2 of our sheriff's departments bought one initially in Catoosa County and Dade County, and we were handling, during the pandemic, all of the hearings involving inmates via that system. Those counties had no cases of COVID in the jail. Our 2 counties, which did not have a system at the beginning, were transporting inmates back and forth, and both had huge outbreaks in the jail. One of those counties has since purchased a system. The other one's trying to get funds to do so. Also, we've just started jury trials this week. We're using our system since we've got to control the numbers in our main courtroom where we're sitting jurors for actual jury selection. We're not allowing in spectators. We're live streaming those events to our other courtroom where this system is set up so members of the public can watch the proceedings that are going on. So it's been an immensely valuable tool, and so I'm in favor of the bill, and I'll be happy. And one of the real world situations, Senator, on your question about use during a trial, we had a situation where, and this is actually a defense witness, was not available. They were on vacation and had not gotten their subpoena. The defense bar came and said, hey, can we get this person on that system for the trial? And we agreed. Their witness was able to get on there and testify even though they had not been properly subpoenaed and they were out of the state, and they were able to get that testimony for their client during the trial on this video system. And I'll be happy to take any questions on specifically how we've used it.
Is the rules chairman your senator?
He is.
He's a big fan of this bill. I think he's going to carry it if it passes, I believe. I think that's correct. Any questions? All right, thank you very much. Thanks for coming down. Actually, we have one late arriving question. Sure. Senator Jones.
Thank you, Mr. Chair. I just have a question still echoing what Senator Cowser was talking about the other day. The talking to people in the hallway and things of that nature where a lot of times you can get a feel for a case. And all of you who testified are trial lawyers, so I trust. I mean, there's no more concern that kind of feel of witnesses now is going to be gone?
Well, during a trial or any kind of like a contested probation revocation, a motions hearing, those witnesses, that's going to be live. Now, during the pandemic, we've been sort of forced not to have those live. But once the emergency order is gone, those will be live. And for trials, any motions that when we're coming to trials, those people are coming over to the courtroom. Their motion hearings are there. They have to go back and be quarantined, though, when they're coming over from the jail. But those are live. And so when we get to those, what we were using it for before the emergency of the pandemic was somebody's in prison and we've just got to do an arraignment. They've got a motion for new trial. That's just argument. We're not putting up any witnesses. It's just the 2 lawyers arguing about what the judge did. They've got, maybe they're in prison for something from another county and they've got outstanding cases with us they want to wrap up. Those sorts of things are what we've used it for. We don't have to, transport someone again and again and again. Like we've got Hays State Prison. We get a lot of crimes out of Hays State Prison and they move all the inmates involved. And then when we get to court for arraignment, they got to transport everybody back. We've had a murder case with 12 defendants from Hays who all got sent somewhere else. The state had to send 2 Cobra team officers, it was also gang related, to transport all 12 of those inmates for arraignment, for first appearance, for calendar call, and then for trials. That's a lot of manpower. We were using it for those kind of things, not talking about what you're talking about when you got to kind of talk to your witnesses. It's no substitute for that when you're having a trial or a motion hearing. those witnesses have got to be there.
Okay. All right. Thank you, Mr. Chair.
Senator Cowsert?
Now, just out of curiosity, where does this say that those will be live after the pandemic's over, which apparently the judicial emergency is already over, according to the Chief Justice, right?
Well, he's not.
This bill doesn't say that these hearings will suddenly be held live. It says it's up to the court rules, right?
Well, the court rules don't permit, like a contested revocation has to be done live, except under the emergency order. We've been pretty much forced to handle a lot of things remotely under the emergency order. Now, the U.S. Supreme Court requires, as part of the confrontation clause, anything at the critical phase is going to have to be live. So again, before the pandemic, we were doing things like arraignment, motion for new trial, where there's no witnesses, probation revocation where the defendant's admitting it, those sorts of things. So the rules themselves don't permit, Rule 9.2 doesn't permit jury trials or those sorts of things to be done. My understanding is that's only being done under the emergency order for revocations.
Okay, well, the way I'm reading this bill on line 28, it has the part about the guilt and innocence of a criminal. It says, then it goes on to say, unless otherwise authorized by the court rule. Now, we have no idea what the court rule is going to be tomorrow. And we are deferring to the judicial branch to set court rules or agreed upon by the accused. Now, I'm with that if the accused is in agreement. But I have some grave concerns about us as the legislative branch. I know Judge/Representative Gunter probably is wearing both hats now and beginning to kind of feel how it is to straddle that line. I mean, we're delegating to a equal branch of government power to basically pass laws and set whatever rules you think are appropriate for an accused to be required to waive their right to confront witnesses against them, to be in open court, et cetera, other than the constraints of the United States Supreme Court.
But those are some pretty big constraints. The United States Supreme Court, no matter what this body passes, they can still say you can't do it.
We shouldn't be passing unconstitutional laws if we can make sure they are constitutional.
Right. And Rule 9.2 does not permit a jury trial to be done, and I can't imagine the Georgia Supreme Court ever permitting a rule which would violate the U.S. Supreme Court's rules about the confrontation clause. And I know that the judge behind me wants to jump in here and answer that, so I'll yield for him to answer that. I'm used to judges cutting me off anyway.
Wow. No, thank you for that question. And I do understand exactly where you're coming from, sir, because what we're asking you to do is something unusual, and we understand that, to codify essentially rulemaking that we have already done. But I will say this.
And may do in the future.
Exactly. But what I will say is this. The district attorney is exactly right. We have constraints that come from the United States Supreme Court. And if you look at Rule 9.2, which is the rule that shows us how we are to conduct felony jury trials, it is actually written in an opposite fashion from Rule 9.1, which is the rule that covers civil trials. Rule 9.1 is an inclusive rule that says essentially all hearings and things can be conducted by video unless otherwise prohibited. In criminal cases, it is an exclusive rule that says only the following types of hearings may be conducted by video, and it specifically lists the types that have been specifically approved or that have not specifically been excluded by previous rulings of the United States Supreme Court. And we wrote it that way on purpose, and I say we, the Judicial Council, the Supreme Court reviewed it, and the other classes of courts that wrote rules with respect to that wrote them in that way for that very reason. And I know that may not alleviate your concern, because I know you're right. We could have a rule change in the future, but we can only have that rule change, as I said in response to Senator Hatchett's question earlier, if the United States Supreme Court were to change its stance on what is a critical phase of a criminal trial. Thank you for letting me speak.
I have just one. Are you done with your question?
Go ahead.
One follow-up on his question. One thing I'm still confused on the bill, in line 17, we authorize hearings to be conducted this way. And then we use the phrase criminal trial on line 27. And so I'm still not clear on, because I think it alleviates a lot of the concerns that, like Senator Calvert raised, if these are just going to be hearings at least, and there's never a circumstance where you can do a trial virtually based on the bill. But it is confusing when you say hearings can be conducted, then you provide a exception on a criminal trial. So help me with that.
Right, and the hearings would be things like arraignment is a hearing,
Right.
But it's pretty, administrative. A probation revocation for the person's admitting, and all you're doing is the judge is going to determine sentence. That's a hearing, but you're not putting up live witnesses. And I think the exception is important for the trial for the situation I mentioned before, where you've got a witness that maybe isn't in the state. Our particular witness was in California. This was a witness the defendant wanted to call in a rape trial to testify for him. Wasn't able to get him subpoenaed, wasn't going to have that testimony unless we did it by this video system. And if you don't have any exception for that, then that would not be permissible, that situation.
Can I ask, I don't want to interrupt you, but if the defendant consented to it, despite the law, would it still be permissible?
Well, I mean, he'd have a harder time appealing
that.
But,
well, I guess like an assistant issue with his counsel and appeal, I guess. If
right, then he could turn around and claim ineffective assistance.
That's where I'm looking
permitting for doing something that was not permitted by the law. But I've also got, even that is the rules permit something, we're not going to consent to it if I think it's going to cost us a reversal at a higher court, because we're the ones who are going to have to go back and tell that victim in the case, look, you got to do it all over again for some technical rule violation, and we're the ones that have to go back, and my folks have to try the case all over again. So we have an incentive to make sure that we're following the Supreme Court's rules as far as not violating the confrontation clause, because we're the ones that have to go argue and try and support the conviction at the appellate level.
I guess the last thing I'd ask then is it your intent with the bill? I know you can't answer this directly yourself, but any feedback anybody has to include trials? Is hearings on line 17, does that also include certain types of trials as well, or is the intent to limit it to hearings?
We're never going to have, nor would I ever consent to a jury trial via video, other than like the situation where that with a witness that's not, no, we couldn't get there any other way and everybody agrees. Like I said, pre-pandemic, we used it for arraignment for folks in prison. We used it to do pleas, folks that wanted to clean up their cases, revocations where they were admitting, and those are the kind of situation, motions for new trial where it's just legal argument. And you're not putting up any evidence, there's no witnesses, and the defendant can hear just as well and participate via video in those sorts of things.
Okay, thank you. Judge Kell, do you want to comment on that?
Yeah, I just wanted to add one thing to that because I don't want to mislead the committee. The Confrontation Clause of the United States Constitution does not apply to civil cases. So I can certainly see that there would be civil trials that could be conducted by video based on a number of factors. But yes, I don't want the committee to misunderstand. I think in civil cases, a divorce trial could potentially be heard by video. And again, I don't want you to be misled on that the Confrontation Clause only applies in criminal cases. Rule 9.1 and Rule 9.2 are two different rules.
It's just my read of the bill that wouldn't be allowed because I'd argue that's not a hearing, but I guess that's up for debate. But it is the intent to include trials, civil trials as well.
Perhaps, yes, sir.
Okay. You want any other questions before we let the author have the last word? Go ahead, Representative Gunter.
I would add that even in civil trials, as a judge, I wouldn't force anybody into a virtual hearing if they had an objection to it. And I can't see any other judge that I know of that would do that. That's just, I'm talking from my experience, but I'll take any questions now.
Well, I'm glad to hear that, and that's been my experience. That even on depositions, unless the parties both agree, nobody's been forcing us to waive our right to be there live. And I wish that was in your bill, that this was if consented to by the parties, especially if it's an evidentiary hearing. There's a whole different deal. I mean, a pretrial conference, we're the happiest people in the world that we don't have to drive, an hour and a half to go to court just for shift some papers around. But when somebody's being questioned, and I can't figure, it says telephone or video, how do I subpoena a witness to appear at a hearing? Do I say, be on your Zoom on this number at this time, or do I say, be on your telephone? And how would I ever give them a document and say, you know, is this your signature? Is this true? I'm befuddled that this bill sets it up where the judges now can compel us to do that without the consent of both parties in civil cases.
Well, again, if I had anybody object to that, I wouldn't go forward with it.
But your bill doesn't say that. Your bill says a judge can by whatever rules they set.
Yeah.
Right?
I understand.
Okay. And this is forever, not just for the pandemic or when it's not convenient for them.
I guess my response is that we have these rules currently in place, 9.1, 9.2, and we're not having that problem now. That's all I can tell you.
But you're not. Can I ask one? You're not asking us to codify that portion of the rules. You're asking us to defer to the judicial branch to allow them to set rules beginning 5 minutes from now if they want to, and on into the future, that are binding on both parties in a civil action and in a criminal action, everything other than their constitutional right to a trial by jury and right to confront witnesses.
You're correct. I mean, you know, but it just doesn't happen.
I know.
Yeah, I understand. I understand.
But you're saying you can do it now anyway in Section 1 of your bill.
But we're guided by the Supreme Court and the cases that come out of it, and so that's what the limitation is.
Okay, thank you.
Any other questions for the author of the bill? Is anybody else that want to be heard on the bill? Mr. Snipes.
Mr. Chairman, this is Dan Snipes. I'm the past president of Georgia Trial Lawyers Association. In response to the question that you raised about whether or not this would apply to civil jury trials, as the Georgia Trial Lawyers read the bill originally, we were of the opinion that it just applied to hearings and did not take a position on the bill. But to the extent the bill would somehow allow judges to order civil trials to be held virtually or remotely without the consent of the parties, we would oppose that. We first would think it violates the 7th Amendment of the United States Constitution and the corollary to the Georgia Constitution that allows civil jury trials. But beyond that, it's just one of those things. I think a lot of the points that Senator Calsert made are true for any type of evidentiary hearing and would be most true at a trial. So we would ask that the bill at least be clarified to make sure it doesn't apply to civil jury trials. Thank you.
All right, thank you. And I will say the way it's written, it only says hearings. And so, all right, Senator Hatchett.
I'd like to offer an amendment to clarify that, if we can.
Let's get a motion on the bill. You want to make a motion? Motion to pass.
Oh, okay.
By committee substitute on the bill. Senator Hatchett.
Move to pass.
Do we have a second? I'll second for the purpose of moving it forward. You want to offer your amendment?
I would like to amend by adding a section F. Or excuse me. I think the best way to amend this and help me with it here. In section C, if we said, notwithstanding the provisions of other subsections of this code section, to the contrary, video conferencing shall not be authorized for use in any criminal or civil trial. And then you put a period and scratch the rest of that subsection C.
Do you want to still leave it less agreed upon by both parties or something like that to still allow it where there's an agreement? I think that would probably, Senator Cowles, it seems like that would clear up a lot of the issues that we see with the bill. But I do think there's some merit to, if the parties consent, and obviously they can waive, I guess.
I'll do my amendment just as it is for right now, because I haven't thought about the constitutional aspects of whether or not a criminal could technically consent in this situation. But I'd leave it with that amendment right now.
Do we have a second on the amendment? Second. I would suggest, if you want, before we vote on the amendment, that we move the bill into rules, knowing that we still have time. We can work on this and make sure we get it right. I think we all shared the same, at least everyone that's spoken shared the same concerns. If the committee wants to do that. So let's first vote. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. It passed unanimously. Any other amendments? Senator Calsert.
I could give you 10, but I'm going to try to do it in 2 or 3.
I
It really
understand.
calls more for a committee sub, no disrespect to the author. On line 17, if I'm in the right version, I may or may not be, where it says, a judge of any class of court or justice of this state may conduct hearings by telephone. Am I at the right place, or am I on the wrong version? Okay. I would like to insert between conduct and hearings, non-evidentiary hearings.
Do we have a second on the amendment? Second. Any discussion? All those in favor of the amendment, please raise your hand. All right, carries unanimously. I mentioned this last time. I think there's a suggestion that we also make the effective date upon the signature of the governor. Does anybody want to offer that amendment as well?
I can do that because I was going to ask that it sunset so we can have let's see how this works. It sort of came across our desk this morning on the COVID liability bill, how sometimes it's nice to be able to revisit one, and we're doing a pretty drastic shift to the law. We already passed one that took away the right to a speedy trial, essentially, for a period of time. So I'd like, I don't know how you word that. Maybe your folks can do it to say becomes effective upon the signature of the governor, but shall, sunset. Let's call it July or June 30th of 2022.
Okay. And we can get that language down to sunset with legislative council. Does everybody understand the amendment? Is there a second to that? A second. Any discussion? All those in favor of the amendment, please raise your hand. Passed unanimously. Any other amendments? We're now back to the underlying motion on the bill. Motion to pass by committee substitute. All those in favor of the motion, please raise your hand. We have 1, 2, 3, 4, 5, 6, 7. Are you 5, 6 then? All those opposed? 2. All right. Thank you very much.
Thank you, Mr. Chairman, members of the committee.
Thank you. All right. Senate Bill 363 is going to come off the agenda tonight at the request of the author. He had a conflict. We'll move that bill to one of our next hearings. I'm going to go slightly out of order, and I'm going to do this with the understanding this is a hearing only. I want to give Representative Rich a chance to present her bill. And there's 2 people that signed up to speak, but no, I will let you speak again at the next hearing we have. She has a conflict that she needs to get to, but since it is hearing only, I will ask that you can still speak, obviously, if you signed up, but remember, you'll get a second chance at this, so I may limit you a little bit on it. So let's go to the back of your folder, Senate Bill 94. I have LC 289958. Representative Rich, the floor is yours.
All right, thank you, Mr. Chairman, members of the committee. I bring to you House Bill 94, which is LC 289958. This bill was requested by our U.S. Postal Inspector in response to the increase in mail theft and porch piracy across our state. Mail theft is currently a federal offense, but the exponential increase that we have experienced in this crime has made it such that it's practically impossible for our federal prosecutors to sufficiently address the issue. So they have requested that we provide a procedure for our local prosecuting attorneys to address this problem at the state level. House Bill 94 would allow a local prosecuting attorney the discretion to charge a felony when an offender possesses 10 different pieces of mail that are addressed to 3 different people or addresses, or when an offender actually approaches the doorway, threshold, or porch of someone's home in order to steal a package. At the state level, mail theft and porch piracy are currently treated as felonies only if the items that are stolen amount to a value of $1,500 or more. So there's little incentive for prosecuting attorneys to prioritize their resources to prosecute these misdemeanors. And this is, I'm stating this as my understanding based upon my conversations with the Prosecuting Attorneys Council. These misdemeanors would typically be a catch and release. So we can't effectively address this issue right now as it's being presented here in our state. Sophisticated crime rings as well as gangs are actually actively involved in mail theft and porch piracy in Georgia. The U.S. Postal Inspector Agent Spears is going to talk with you and show you some photographs of a search warrant that was issued in January and explain to you why that crime is essentially going to go unprosecuted, even though it's pretty widespread. House Bill 94 would just give law enforcement some options and some tools to address this serious gap that we have here and protect our citizens. Low-income individuals as well as the elderly are much more impacted by this crime than the rest of our population. And that's because with the elderly, they clearly rely on home delivery of medications, essentials, benefits checks, and their porches and mailboxes are a target-rich environment. In addition, criminals oftentimes view our elderly as easier targets. Our low-income communities also use what's called cluster boxes. Those are those big multi-unit mailboxes that you see a lot of times in apartment complexes. These are very efficient for the mail theft rings because they pop them open and they're able to steal from many different people at the same time. This is really disruptive to our low-income people if they miss a benefits check. Well, they may not have money to make rent or pay for their food. So it can be really disruptive in their lives. Our laws have always treated burglaries as a felony. This is because it is a much more brazen act and a much more brazen criminal who will actually go into someone's home. So anyone who puts even so much as a toe across the threshold into someone's home with the intent to commit a crime could be charged with a felony. This law really just kind of updates where we are as a society. In the past, criminals didn't have a reason to go up to someone's threshold or their porch or their doorway because we didn't have packages delivered like we are now. This was a problem before the pandemic. It has become even more of a problem now. More and more people have engaged in e-commerce. They're relying on it. Our merchants are relying on e-commerce, and we've got to protect that, and we have to protect Georgians. So this bill is just a move toward that, and again, this has the support. This measure is supported by the Prosecuting Attorneys Council, and I am happy to answer any questions for you, as well as Agent Spears is going to speak in a moment too.
Any questions for the author of the bill? All right, we'll have Inspector Spears come up if you'd like and speak as well. Like I said, I don't want to cut you off, but I will give you another chance to speak on this at the next hearing we have as well.
Thank you, Mr. Chairman. May I remove my mask? Yes, sir. Like Representative Rich said, my name is Keith Spears. I'm a U.S. Postal Inspector. If you haven't heard of our agency, I'm a federal agent, law enforcement officer that enforces federal law as it pertains to the post office or the criminal use of the mail. I greatly appreciate Representative Rich spearheading this legislation. We started working together in 2019 because the problem is out of control. I have traveled out of state to interview prolific mail thieves that are traveling groups and that have been arrested, and they'll use the term 404, our area code, for this in other states because it's a well-known problem coming out of Atlanta. And it's affecting Georgians across the state. There's thousands of reports of mail theft every year. As the representative said, it does most prolifically affect our elderly who rely on medication through the mail and e-commerce, and who may not feel comfortable going out at night to check their mailbox if the mail comes late. It also affects our lower socioeconomic groups. They have a harder time repairing and up-armoring mailboxes and receptacles or getting security cameras in place, and they just get targeted over and over and over again. So we did provide some photos just from some recent cases to Representative Rich that she provided to y'all.
I can pass them out.
Oh, I'm sorry about that.
I'm sorry, I should have passed these out to you all.
As she's handing those up, I'll just make a few other points very quickly. what we see very commonly is local law enforcement calling us. It's a middle of the night, and they've pulled over a car, and in that car there are hundreds, if not thousands, of pieces of mail. Or maybe they respond on some other offense, and they respond to a hotel room where one of these groups has set up shop to counterfeit checks. And unfortunately, right now, they're held to a theft by receiving misdemeanor charge, because that person could have a check for tens of thousands or hundreds of thousands of dollars, and it's only worth the paper it's printed on. But as you'll see here, these are just a couple recent in the past year cases. The first is a single person stealing over 400 Amazon parcels, many shipped through the U.S. mail. That person was not charged by local law enforcement in DeKalb County because the victims were all out of their jurisdiction, and on the federal side, it just does not reach the dollar loss to become a priority matter. So that offender, while we're still pursuing charges, that offender is still out on the street. If you go through to the fourth page, you'll see collection box units at a lower income apartment complex that I responded to after the first round of federal stimulus payments went out, that were all just pried open. This is a nearly everyday occurrence, primarily at the beginning of the month because of benefit checks, but this happens all the time. And then the last two pages are when we responded out where law enforcement had gone into a hotel room and they were investigating a group of folks that were using narcotics and were doing mail theft and stealing mail to fund that addiction. And you can see this is just, again, just a routine response for us, where they take over a hotel room, they've got checks, printers, ID makers, and they're establishing an operation to go out and counterfeit checks. So that said, I think this would be a huge tool for local law enforcement, for us to work together with them and to protect our Georgians. It's victim-centric legislation, and we, again, thank Representative Rich for that. And I'll take any questions at this time.
Question from Senator Parent.
Thank you very much. Thank you for being with us. We definitely want to make sure we're addressing update in crimes with the shipping of packages. My question is, to what extent, I think you touched on this a little bit, are current laws against theft inadequate?
So for the most part, these are leading to misdemeanor charges of theft by receiving, where we are catching and releasing offenders, and it becomes an organized criminal group where a couple hours in jail are just the cost of doing business. But it is a very lucrative. We're seeing gangs moving from narcotics trafficking into fraud of this nature, primarily because of the difference in the sentences and how it's handled.
So the larger concern is sort of more criminal enterprise, or repeat. So the way it's drafted, though, you could, I order lots of things on Amazon. Could be some, $5 hairband or moisturizer or something, and some 17-year-old could steal it, and that's a felony. Would you consider a monetary amount or needing to be a repeat offender kind of more akin with the criminal enterprise that you're discussing? No,
Representative Rich and I have spoken, ma'am, and that is essentially putting us right back where we are. The dollar amount, this is an offense that sets up follow-on offenses. So it sets up bank fraud, it sets up identity theft, and it would gut the legislation.
It would gut the legislation if you can't put a 17-year-old in jail for stealing a hairband? I'm sorry.
No, ma'am, that's not what I said. If we're putting a dollar amount, there already is a dollar amount that would get us to a felony. The idea being that when they go up on someone's porch, it is a grab bag, and we understand that. But what we are seeing in the offenses that we're looking at are when folks are being pulled over, they have a ton of mail on them, and it's not usually, the calls we get from victims are not a hairband. It's their cancer medication that they can't get the VA to reissue. It's things of real importance to them.
Okay, thank you.
Any other questions? Thank you, Mr. Spears.
Thank you.
We have one other person signed to speak on this bill. It's Thomas Weaver. Mr. Weaver. And obviously, I'll extend the same courtesy to you. If you have more, do you want to share the next hearing?
Thank you, Mr. Chairman, members of the Senate Judiciary Committee. I can learn to better appreciate what Representative Rich is trying to accomplish in this legislative measure, but as I have shared with this committee in years gone by, I want to reiterate on second occasion that I think that this committee should have a presumptive bias against creating a new felony crime, especially at a whim, and especially for conduct like this. It's not often that Senator Parent and I agree, but when we do, I tend to agree with her wholeheartedly. And indeed, under current Georgia law today, a 17-year-old is automatically an adult for the criminal justice system. If a 17-year-old, as contemplated under the example that she provided, were to approach a residence, even the porch even, and swipe a package that say a $5 hairband, they'd be caught up in a felony in this. And a felony has very severe collateral consequences. Well, discussing felonious criminal conduct, I think that it is important to point out that the United States Postal Inspector just alluded to that currently, under the laws of Congress, under Section 1708 of Chapter 83 of Part 1 of Title 18 of the United States Code, it's already a felony to steal mail. It's already a 5-year felony. Under federal law today, it's already a felony. And the United States Federal Supreme Court back in 2019 under Gamble versus the United States upheld the doctrine of dual sovereignty by a 7-2 decision under the Roberts courts. It said that if a person is apprehended for conduct that can be governed under both federal and state law, they can be prosecuted under both. So they can get a double whammy. And then I suppose that someone could come along and say, well, felonies that are punishable under indictment under the charge for less than 10 years could be prosecuted under misdemeanor under the 1710-5 out, which is current law. But that doesn't dispossess a criminal defendant of any of the collateral consequences, even though the judge would adjudicate a misdemeanor sentence in that case, and the person would receive a misdemeanor sentence. The person would still have the felony collateral consequences that travel along with the underlining felony conviction. So to the extent that the legislature has a legitimate vested interest to define crime and a fixed punishment, certainly. I listened very carefully when this bill was being discussed in the House. People do have a right to feel comfortable in their home, and the porch is the pertinent premise or pertinent portion or partition of their home. But the burglary statute, as was alluded to by Representative Rich, is clear. You have to enter the home. Here, there's no entrance. That's current law today also. So if it should meet with the committee's approval, I would just ask in approbation of the comments that were placed by Senator Parent that this committee have a presumptive bias and either assign a current amount, which was spearheaded by the former administration under Nathan Deal's criminal justice reforms, or conversely, make it where the criminal defendant would have to have priors before they get put into felony world for this type of behavior, as opposed to just laying down a $5 felony hammer. If it just so happened that the package had nothing but glitter in it, because, you know, it just seems to me to be a little bizarre to say that if you walk into a store and you steal that $5 item, you're just a misdemeanor. If I steal $5 from your office, that's just a misdemeanor. But lo, if I steal $5 off your porch, it's suddenly a felony if it happened to be in a package. It just seems to me to be bizarre to split public policy in that regard, and I would ask that this committee be sensitive to that, please.
Thank you, Mr. Weaver. Any questions for Mr. Weaver? All right, thank you very much. That's everyone that signed it to be heard on this bill. We'll move that bill to another calendar. Thank you very much. Next bill on the agenda is House Bill 562. Representative Carpenter.
Man, this is the easiest bill you've seen all year.
Have you seen the substitute to the bill?
No, I have not,
okay.
and I don't really want to see a substitute.
Okay. We have a substitute, LC 393043S. And I believe Section 1 is your original bill.
Which
if you want,
easy bill.
Why you don't think section 2 is easy?
I haven't seen it, thank goodness.
Why don't you present section 1 to us?
Absolutely, I'll be glad to do that. So this was a simple bill. I believe I presented last year in this committee as well, and would simply add DFACS case managers to the list of folks that we're already allowing to, when warrants are issued against them, that it has to be a judge of superior court, state court, or probate court. So we do that with peace officers, law enforcement officers, teachers, and school administrators, and we're just asking to add DFACS case managers to this list as well. Simple bill. I think it just caught up in crossover, or I mean, at the COVID, Sonny died, tough times. I'm not sure what happened, to be honest with you, but it was a good bill last year, and I think it's a fine bill this year. Something happened.
Any questions for Mr. Carpenter? And the substitute, you can stay there if you'd like.
No, I'm good. I've done all. If you don't have any questions of me, you can feel free to continue.
All right. Thank you very much. I appreciate that courtesy. Section 2 is a House bill that, you now on the committee?
Yeah.
Okay, yeah.
I'm gonna vote yes.
This is.
Do I have to sign a waiver or something? Vote yes on anything?
Well, Saz, this is how we have fun on St. Patrick's Day when you're in the legislature, I guess. This is our idea of fun.
Go drink a green beer.
Yeah.
I'm having flashbacks in this room.
Section 2 of the bill is a House bill that did not cross over, that is something that we added to this bill that deals with situations in a criminal case where you have a prosecutor has a limited way to also petition a court to have a change of venue for a trial. It's something that a defendant already has the right to do, but generally prosecutor does not have this right. And we made a very limited circumstance where you have a situation where a previous prosecutor has been recused from the case or been disqualified or removed from the case, or the local government official has publicly released information that's been prejudicial to the administration of justice. What this is doing is looking at those narrow situations where a prosecutor is coming off a case, and a lot of times when that happens, you have issues that may be tainting the whole jury pool in an area, and there's no current way that issue can be put in front of a judge, and this bill will allow that to be put in front of a judge. And the second part you'll see on page 3 creates the same standard and process as you currently have when the defendant requests the same thing. Does anybody have any questions on section 2? We have.
Is that the venue part we're talking about?
Yes, sir. Yep.
Does the state have a constitutional right to select venue, or have we statutorily set that, where the offense is committed, et cetera? I don't understand. I'm not sure whether that's a constitutional provision or statutory, but I know a lot of prosecutions fail because the prosecutor failed to adequately show the crime was committed within the venue where it's being prosecuted, et cetera.
Right. I don't know if that is something that comes from the Constitution or statutory. Obviously, we have still the ability to change a venue, and so there has to be the way the legislature can do that.
Yeah.
But I'm not sure if that's something that is.
Did this piece of it pass the House?
I believe it's stalled in rules in the House, I believe is my understanding.
I don't mean to derail it. I just don't know. That just jumped in my mind.
Okay.
That doesn't mean it was a bad bill. A lot of good bills get derailed in the House.
We're not talking about you. It wasn't part of your bill. You have good ones.
We had one person that wanted to be heard on the bill, Ms. Maisie Lane Causey with GACTL, Georgia Association of Criminal Defense Lawyers.
Thank you, Chairman Strickland, and to the members of the committee. Thanks for hearing from us on this bill today. To your question, Senator Kauser, this bill was not vetted at all in the House. It did not make it to rules. This is Representative Bodie filed this bill, but it did not move forward at all. It is being added here simply as a vehicle. And our strong concern is partly what you are addressing, and that is the right to an impartial jury is a right that the defendant holds in a case. The state, the Bill of Rights is not inured to the prosecutors. And under our law right now, we do have the statutory right as a defense to ask for a venue change when we feel as though the jury pool has been tainted. I understand if the language, I have not seen the exact sub, but if the language does track House Bill 140, which is my understanding that it does, it's a modification to that same code section where the defense venue change is allowed. And I do see what you were talking about, Chairman, where it is a very narrow set of circumstances. The narrow set of circumstances that are laid out in the bill do strike me as having just occurred in Brunswick, Georgia, over the course of the past year. And it does concern us that a new statute would be written simply because there was one instance of behavior or missteps on the part of the state, that we would then change our entire venue code because of one situation. And the situation that comes to my mind that matches the facts that matches the contours of this bill are the missteps by the prosecution in the Ahmaud Arbery case. I don't know that for a fact that is what this bill is targeting, but the situation that is outlined in the bill certainly does track with what we know about what happened in the initial stages of the prosecution of that case. So our request would be that this bill, that Representative Carpenter's bill go forward as filed without the additional language that's been added with respect to venue, because the right to an impartial jury is not a right that the prosecutors enjoy in any state in our country. Rights are for the defense. The state has the power to bring these prosecutions, and the defense should not be hamstrung because of their bad acts or their missteps in the way that they handle their prosecutions. And we would certainly ask that you not create an entire new law based on one situation that was mishandled in our state. And I would certainly stand for any questions that you have.
Any question for Ms. Causey? Senator Parent.
Thank you, Mr. Chairman. I'm wondering if it also would be applicable, and there may be many other instances, but I was thinking about the situation in Fulton right now with the claims about the actions as it relates to the former District Attorney Paul Howard in dealing with both of those cases last summer. I see there are some, obviously there are some differences there, but some of these facts seem to me to be a little bit more broadly applicable.
Well, as I recall, District Attorney Howard was not removed for cause from any of the prosecutions that stemmed, I'm assuming you mean, like, for instance, from Mr. Brooks' death.
And the other one, there's another case too.
Maybe, I'm not sure what the other one would be besides, the other case I know that's gotten some attention has been there were some students that were tasered.
It's that one, yeah.
Okay. But in both of those cases, there was not a district attorney removed for cause.
But isn't the current district attorney is trying to recuse or not be a part of that case anymore?
Well,
so then if there was another one,
right? But if a district attorney, sorry, didn't mean to interrupt.
No.
If a district attorney asks to be recused from a case, that's quite a different situation than having been removed for cause. A removal for cause is going to happen because of bad acts. It's not a decision. That's not the district attorney coming and asking to be removed. To be recused from a case because the district attorney believes she has some kind of conflict is the right thing to do. And that should not then trigger a venue change. The venue should still rest in that county. That happens pretty frequently. I mean, I shouldn't say pretty frequently, but when there is a request by a district attorney to be recused from a case, it's not customary then that there would be necessarily a change of venue. I mean, the defense might find there needs to be because of that kind of.
But the prosecution couldn't find that there needs to be.
Not as we stand today, no ma'am.
Okay, thank you.
I want to address, and then I send to Calzer the question. The question about the Constitution, Julius has sent me, paragraph 6 of the Constitution closes with all criminal cases shall be tried in the county where the crime was committed, except cases in the superior courts where the judge is satisfied that an impartial jury cannot be obtained in such county. So the read of that means this is a constitutional protection is available to both sides, so our statute may only contemplate it for defendants. It's equally by the Constitution available for the district attorney as well, the determination of a judge. Do you have another question, Senator Calzer?
Well, I was going to ask pretty much that question because I can see how the state, the DA, represents all of us. You know, it's the people versus so-and-so, and we have a right to a fair jury also, and if the state prosecution thought that the jury panel was tainted or whatever, it would only be fair unless there was a constitutional prohibition against it. So I was going to ask you to direct me to that kind of case law, or that sounds like the Constitution is neutral as to the party.
It does sound like that, and I did not realize that part. I wonder, would you mind reading the second prong of the allowance? I know that there's the I'm sorry, thank you.
You're flying in the dark.
I am, thanks.
She's talking about the constitutional provision, I think.
No, I'm talking about the bill. So,
okay.
So then I guess if to get down to a little particulars in light of the apparent neutrality of that constitutional provision, the fact a specific concern I think then we would have about lines 41 and 42, whereby a local official has publicly released information that's prejudicial. What then stops the local district attorney from in fact doing that and setting up a course for a venue change as a strategy? I mean, that seems problematic. That wouldn't be a response to a bad act by some other county official. The very district attorney herself could choose to do that and in order to force a venue change. That seems very concerning to us.
If I may respond to that, though, I mean, I know what you're saying, but the thing is, this has to be weighed by a court, and I would hope that a judge would point that out. That'd be pointed out by defense counsel if it's done on purpose. I get what you're raising, but that's one of those things where I feel like it's hard to write, don't do this into the law, but I would hope that would never happen, because that's why you have the check of the judge looking at this, obviously.
Yes, and of course we're always in favor of the court having ultimate discretion on a matter. It doesn't sound like there is much will for modification, but we are definitely concerned by this being what seems to be pretty reactionary to a single situation, and also this idea that I've just explained around the potential for bad acts to cause a venue change without a legitimate reason. Thank you for hearing from us.
Yeah, thank you. And Mr. Skandalakis, do you want to be heard to answer the question we asked as well?
Thank you so much. It's a pleasure and an honor to be in front of you. I respectfully disagree with my friend, Ms. Causey, and I agree with Senator Calvert, Chairman Calvert, that everyone's entitled to a fair and impartial jury. That means the state as well as the defendant. That means the victim in a case is also entitled to a fair and impartial jury. And the whole process of a jury trial is to seek the truth. And if you have a jury coming in that's prejudiced about the case before they even start hearing the case, a judge should make that determination. And the way this particular code section, particular bill is written, there are explicit instructions, explicit directives that a judge must consider. One is the recusal of the DA or the removal of the DA for cause. The second is prejudicial statements. And if a DA makes a prejudicial statement trying to get a change of venue, he or she is in direct violation of Rule 3.8. And one of the things that the DAs are trying to do and the Solicitor Generals are trying to do is we're trying to strengthen the penalties for violation of 3.8 to include disbarment. That's how strongly we feel about it. But I will point out something. Just prior to this hearing, I did a survey for the National Association of Prosecuting Coordinators, and it was real quick. I had 14 responses. Of the 14 responses, the question was real simple, is does your state permit a prosecutor to seek a change of venue? Out of the 14 responses, 3 were no, 11 were yes. Florida, yes. Virginia, yes. North Carolina, yes. New York, yes. Idaho, yes. Louisiana, yes. Colorado, yes. Pennsylvania, yes. Arizona, yes. North Dakota, yes. Minnesota, yes. So I imagine by tonight, by the time I get home, I'm going to get more responses and we're going to have more yeses. And it all boils down to one basic tenet, and that is everybody's entitled to a fair and impartial jury. And if you can't get a fair and impartial jury because someone has tainted the jury panel, why shouldn't the state be able to ask for a change of venue, and why shouldn't that lie in the discretion of the court? And that's exactly what we do. It's statutory. The judge can take all the factors into consideration. And if you can't get a fair and impartial jury and you have a victim sitting there at the prosecution table and he or she can't get a fair and impartial jury, then the entire jury process is tainted, and it's of no use if only the defendant can invoke that right. And that's my basis. We support this bill and think it's a good bill.
Any questions for Mr. Skandalakis? All right, thank you very much.
Thank you.
What's the pleasure of the committee? We have a motion to pass by committee substitute by Senator Hatchett. Do we have a second? Second by Senator Jones. Any discussion? All those in favor of the motion, please raise your hand. It passed unanimously. Thank you. See, now your bill's a little more exciting, Representative.
I'll tell you what, man, I tell you, this has been a great night.
And I'll be
Have a cocktail for you boys.
I'll be carrying your bill in the Senate, so it's in good hands.
And ladies, excuse me.
Yeah.
I can't say that, but I'm on probation.
All right. Representative Bonner, can you follow that?
I cannot.
Okay, don't try. Please don't try. So our next bill on the agenda is House Bill 534. And let me get myself together. We're working off of LC 392986 ECS. Now, you know what ECS stands for, don't you? It's too late for hazing. You'll figure it out. Okay. The floor is yours.
Thank you, Mr. Chairman. Members of the committee, I appreciate the opportunity to bring to you House Bill 534. House Bill 534 seeks to address the illegal street racing in a way that is somewhat creative. Our law enforcement community came and spoke with the governor about this issue and had requested some additional tools to combat this issue that is becoming a public nuisance within our state. Drag racing and laying drag is already illegal in Georgia, but what House Bill 534 does is goes an extra step and provides for the following additional offenses of promoting or organizing an exhibition of illegal drag racing or laying drags and reckless stunt driving. I know that this is an issue that is dear to the Senate, as y'all just passed out Senate Bill 10, I believe, last week by Senator Emanuel Jones. And what this does is to help combat this activity in a way that law enforcement has asked us to do. The bill sets forth various penalties, including habitual violator for reckless stunt driving, and lays out a series of suspensions as well as fines. And we did those fines and those punishments in accordance with the DUI statutes to match those as closely as possible. And that's essentially is the essence of the bill, Mr. Chairman, and I'll be happy to stand for any questions. And I do have Mr. Trey Bennett, our policy analyst, available for any particulars that you may have.
And you are full leader for the governor in the House, correct?
That's correct.
And I just want to say I appreciate the governor's work on this. Some people see this as just an issue inside of Atlanta, but I can tell you living in the suburbs, it's becoming an issue in the suburbs. And I appreciate the shout out to Senator Jones, who I share Henry County with, and he has all the way to Decatur and DeKalb County too. And he led on this issue in the Senate. It's my understanding that y'all have worked together and that he's working with you on this bill. Moving forward now in the Senate, correct?
Absolutely, and he's been kind enough to offer to carry the bill for us in the Senate, which is very gracious of him, and we look forward to working with him getting that done.
Thank you. We have a question from Senator Parent.
Thank you, Mr. Chairman. Thank you, Representative Bonner. Can you elaborate for me a little bit more about the current tools available and then what we feel the gaps are? I just today, I think, was reading an article about a big a mass arrest really in Clayton County on this very issue. And so and it did allude in the article to a few things, it alluded to the bill and a couple changes, but I'm still just trying to understand a little more about where the gaps are that's really needed, because obviously all these arrests did take place on this very issue.
Yeah, sure. Thank you for the question. So again, what the bill does is it allows law enforcement to go after those that actually organize these activities, which is a little different than what they have available to them now. And I think what we all see and we'd all agree to is that oftentimes the only reason these events occur is because they are organized. They attract a crowd. They have a purpose. I mean, it's not as if necessarily that a couple of guys are just meeting up, on a vacated stretch of county road and racing their vehicles. People are being invited. Social media is being engaged to get folks into an area and actually participate in this. So what is unique about the bill, or what is different to fill in that gap, is to go after those that actually organize this activity and to essentially to nip it in the bud, to go after it in that respect. Does that answer your question, Senator?
Yeah, I mean,
Okay.
if there's anything else. Okay, thank you.
Any other questions for the author on the bill? Thank you very much. We have, I believe, just one person signed up to speak, Ms. Maisie Lane Causey with Georgia Association of Criminal Defense Lawyers.
Thank you again. I will be brief. Some of the extreme carceral and financial punishments that were included in earlier versions of this bill have been dialed down, and we are really grateful for that and for the collaboration there. We are still concerned, though, that enforcement is a problem with street racing. During the House hearings on this bill and at earlier stakeholder meetings last year, law enforcement opined that it's elusive, this behavior. It's hard for them to enforce it. Obviously, in Clayton County, they were able to kind of box people in according to the media reports, but that's not always the case. And because it moves around, it's so transient, they've had trouble enforcing it. So one of our concerns is that expanding the criminal code when enforcement's a problem doesn't really make a whole lot of sense. And we are continuing to ask and encourage that there be a study committee convened to discover ways to mitigate this behavior. In other parts of the country, there are some really innovative ideas happening. There's a program called Beat the Heat, which was actually established by some first responders, where police officers and firefighters, they use marked emergency equipment in safe areas where they can promote drag racing actually and teach children and young adults how to do these behaviors more safely. They plan the environments. They've got emergency personnel on site instead of taking over public streets for the activities. A study committee would provide an opportunity for all of the stakeholders to contribute to a solution without defaulting to using our criminal legal system as the remedy. The other concern we continue to have about this legislation is the vehicle forfeiture aspect of this bill. 2 years ago, the United States Supreme Court, in a case called Timms versus Indiana, confirmed that the Eighth Amendment's protection from excessive fines applies to the states through the Due Process Clause of the 14th Amendment, and in doing so, suggested that the forfeiture of Mr. Timms' $42,000 vehicle was disproportionate to the felony crime in issue in the case. In that case, the crime carried a maximum fine of $10,000, and the court discussed how the disparity between the value of his vehicle versus the potential punishment of the crime could lead to an Eighth Amendment violation. And even though we know in this bill forfeiture is not implicated until an arrest after a third conviction, because it subjects certain vehicles to forfeiture, this provision would be ripe for a challenge under Timms. Moreover, in this forfeiture scheme, the involvement of the actual vehicle owner in the alleged offense is not controlling. So the person who owns the car doesn't have to be the person that's arrested, and the car can still be forfeited. And we, of course, have concerns about that, knowing that someone who hasn't participated in any way, in any fashion, in the problematic behavior could lose their vehicle to forfeiture. So again, we just continue to, maybe naively at this point, hope that a study committee could be an alternative way of addressing this and finding some other solutions beyond just carceral measures to stop this behavior.
Thank you, Ms. Causey. Any questions for her? All right, thank you very much. And there's no one else assigned to be heard on the bill. What's the pleasure of the committee? We have a Senator Kirkpatrick.
Pass for LC 392986 ECS.
We have a motion to pass by Senator Kirkpatrick. Do we have a second? Have a second by Senator Calzert. Any discussion? All those in favor of the motion, please raise your hand. It passes unanimously. Thank you very much. Who's going to be carrying the bill in the Senate? Senator Jones. All right. Senator Emanuel Jones. All right, thank you very much. All right, next bill on the agenda is House Bill 479. And you're welcome to take your place there if you'd like. Leader Reeves. Good evening.
Hello, committee.
You didn't wear any green today?
I didn't. I don't have anything formal that's green. I have a lot of yellow, though.
They make gold and green that go together. You can still wear your yellow color. And yeah. Go ahead. Tell us about House Bill 479.
Thank you, Mr. Chairman. This is the repeal of the Georgia Citizens Arrest Law, and this has been a collaboration of a lot of folks, a lot of different groups, a lot of voices that really dated back to last summer. The House Judiciary Chairman, Chuck Efstration, led some efforts over the summer and began really expanding on the discussion about the necessity of having a citizens arrest law in Georgia, especially in light of what happened with the Ahmaud Arbery case down down on the coast. And I was very privileged when, obviously Governor Kemp felt compelled as leader of this state to send a message on this issue and to explain that this is not a law that we're going to have, we're not going to honor in Georgia anymore. And so I was very privileged to take over the issue and the work that Chairman Efstration had done. And we've worked very hard this session, and what I would love to do is just kind of briefly walk through the history of citizens arrest. Citizens arrest historically came about in the 13th century. It was codified in Georgia and in many other states during the Civil War years. It was in 1863 in Georgia where it was codified. And there's no doubt that part of the history of this law is tied to retrieving slaves who were attempting to leave their owners to try to join the Union Army. It's also irrevocably tied to lynchings that were justified for decades in Georgia under the concept of citizens arrest. It's been a law since 1863. There's actually 3 statutes, 17-4, 60, 61, and 62. There's not a whole lot of case law on this issue. A lot of the case law is very old, dates back over 100 years ago, and more recently, the case law on citizens arrest mostly deals with the concept of out-of-jurisdiction police officers making arrests out of jurisdiction. And I'm going to talk more about that and explain how what we've done in this bill isn't going to change that. But the best way that I know to describe this is, in 1863, Georgia put a law in place, citizens arrest, and it's been a law for 158 years. And so we have 158 years of jurisprudence and case law that has been derived from citizens arrest. And what has been derived from that has been a way that Georgia law has satisfied or has said that certain detentions are permissible. For example, the concept that a shopkeeper or a Walmart loss prevention officer has the right to detain a suspected shoplifter is something that's derived from citizens arrest. Same thing with a restaurant owner, that somebody that's trying to leave without paying their bill. Believe it or not, weight inspectors on the side of the interstate, if they have to detain somebody because they have something in their car that they're not supposed to have, they do so under the authority of citizens arrest. And private security as well. So and then also out of jurisdiction police arrest. All of these things come from the jurisprudence that comes from citizens arrest. And so if we repeal citizens arrest, which is what this bill aims to do, there's 2 things. There's 2 options. Number 1, we could let the courts figure out ways on how to justify those detentions all over again. Or number 2, we can, what I call, do some patchwork and patch in those common sense detentions that a non-police officer would need to be able to make. And so if everybody is looking at the bill, what I want you to do is I want you to first go to Section 2 on page 3. And Section 2 is the repeal of Article 4 of Chapter 4 in Title 17. And those are the 3 citizens arrest statutes. And then Section 3, right below it, in lines 65 through 101, we have created a new code section that patches in all of these things I've just discussed, with the exception of police officers. And so if you look at lines 75 through 87, this law is designating that retail establishments, food service establishments, weight inspectors, and then private security, which is regulated heavily under Chapter 38 of Title 43, would all be allowed to make a detention, that they would be allowed to make a detention. And what this is essentially is an extension of what they can already do. It's the same thing as what they can already do today. Today they do it under citizen's arrest. Under this, they would do it under this specific code section. Lines 89 through 93 are the rules of those detentions, as far as they have to contact law enforcement within a reasonable time, and that they either have to make a decision to let the person go or to contact police. And so those are the rules. Lines 94 through 95 are extraordinarily important. There has been, you know, every single one of us are very used to this down here. There has been a tremendous amount of misinformation put out on this, a lot of mischaracterization, and a direct attempt to conflate the repeal of citizens' arrest as having an impact on our ability to defend ourselves and what's encompassed in our ability to defend ourselves. And lines 94 and 95 explicitly excludes any immunities or defenses that we as Georgians have under our self-defense laws, which is 16-3, and then it's 20, 21, 22, 23, 24, and it's got some point ones and point twos in there as well. And then 96 further elaborates on some of the on the reasonable force that can be used, which mirrors that in the self-defense statutes. Then if you go back to Section 1 of the bill, you remember I was talking earlier about police officers that are out of jurisdiction. Not every police officer can go everywhere in the state and make an investigation or make an arrest. In fact, there's a lot of rules that dictate what they can and can't do. They have limitations in their boundaries. For example, campus police officers are only allowed to go 500 yards off of the campus. Municipal police officers are not allowed to start an investigation outside of the municipal limits of the city that they're in. There are a lot of, but under the citizens arrest concept through case law, our higher courts have determined that there are circumstances where out of jurisdiction police officers can make arrests and can perform their duties. There's another doctrine of case law that says that a police officer is technically on duty 24 hours a day, and there's a long line of cases that supports that. And so couple that with what do we do when a police officer is out of jurisdiction. So what case law has told us and justified is that, and if you look at the bill in line 48, if an offense is committed in such officer's presence or within their immediate knowledge. So if an officer a Cobb County police officer is at Lenox Mall and observes a crime happen, then he would be permitted to make an arrest. And that currently, under current law, is derived from citizen's arrest. The logic being, how can you tell a police officer that they can't make that arrest if they could technically do it as a citizen? So case law has told us that police officers out of jurisdiction arrests, if they see a crime, is justified under citizen's arrest. So if we're repealing citizen's arrest, we do not want to interrupt how police officers, the limited rights they have out of jurisdiction. And so by including this here, that will allow them the same right that they have currently under case law. It would just be codifying it under the statute that deals with arrest powers. Same thing with B, line 50 is hot pursuit. If you are in pursuit of someone in your police car in the city of Kennesaw, and then you roll over into the city of Marietta, you're technically out of jurisdiction, but because case law through citizen's arrest has justified continuing and making that stop once you cross over, that's okay. So again, we're taking that and we're putting that and clarifying it in arrest powers. And then C is while aiding and assisting another law enforcement officer. If you are driving down the road and you're off duty and you see another fellow officer that's in a struggle or making a case or whatever it may be, you can stop and assist. And again, that is all. And if you happen to be the one that actually places a guy under arrest, it's justified under citizen's arrest. So these are three very common sense examples of how police do work outside of their jurisdiction that is legal and that is that's justified under Georgia law and Georgia case law. So what we're doing is we're taking and putting those into this arrest power code section. And then very importantly, I worked very closely with the sheriffs, and I don't know if they, I don't know if y'all have received any information from them. No one's told me that, but there was a letter that they had placed in the House stating that they had opposition to this, and I worked to accommodate every request that they had, and I have a long track record of working very closely with the sheriffs in my time here. This is an issue that we were not able to come in total agreement on. But I did accommodate their request because their sheriffs have some very specific duties. There's a lot of laws in Georgia that limit jurisdiction of what police officers can do, but sheriffs by the Constitution have an expansion of a lot of things that they do, and a lot of it's jurisdictional expansion. For example, they have to serve orders to apprehend or contempt orders in other counties. And so we added at their request lines 55 through 57 that essentially says that nothing in this is going to have any impact on what a sheriff's duties are to do. So this is very important because, again, in good faith, I worked with them and answered their concern. And the whole purpose of this exercise here in Section 1 is we want Georgia law with police officers investigating out of jurisdiction or making arrests out of jurisdiction, and with sheriffs doing their job, we want it to continue on as it is right now. And that's the spirit of what's contemplated here in Section 1. The rest of the bill is just cleanup where citizen's arrest is referenced in other code sections. And so it's just cleanup of removing language or replacing it with this new 17-4-80. That is the bill. I have received, there's been a lot of criticism, a lot of discussion around this bill, and it's kind of become the mission of my session in a lot of ways has been disarming and answering a lot of this criticism. And again, I tell you, I worked with the sheriffs in good faith. Their other concern that they raised is that they believe that this bill will inhibit a person from being able to detain someone if that person is committing a crime against them. And so it's really important that you understand what I'm about to say. This cannot be looked at in a vacuum. You cannot just look at citizen's arrest and come to a conclusion that all of our abilities to detain folks or to defend ourselves are found within this concept. You have to look at multiple things. And there are some very specific statutes in addition to the self-defense statutes. But in the concept of justification, 16-3-20 is where Georgia law presents justification, where you are justified in conduct that could be otherwise prosecutable. This is where justification comes from. So you engage in conduct that otherwise could be criminal, but it's not criminal. because it's justified. So number 1 in justification lists our self-defense statutes, which I'm going to talk about in a second. Then we go on down to number 5 and number 6. Number 5, when the person's conduct is justified for any other reason under the laws of this state. So we've got a broader, where it's justified on any other law. And then in number 6, even broader, in all other instances which stand upon the same footing of reason and justice as those enumerated in this article. What I have experienced and what you have probably heard from folks is people are reading the self-defense statutes in the most narrow way that is possible to read them and saying, well, because there is not a bright line here, I don't have the right to do this if somebody does that to me. So the first thing I would bring you to is justification is broad. It is circumstantial. It is defined. It is a very openly defined thing that the facts of any particular case can be used to show that you were justified. So we have got something broader than self-defense laws here. But when we move to our self-defense laws, 16-3-21 is the ability to defend ourselves and to defend other people. And there is what we call in all of these self-defense laws the continuum of force, of what types of force you are allowed and permitted to use in response to what's happening to you. And so with that, the law of self-defense allows you to act reasonably. And so because it doesn't specifically say, well, it doesn't say I can detain somebody that's in my house committing a burglary. It doesn't say I can detain them. But it says you can act reasonably, and I submit to you that acting reasonably includes detaining somebody that's committing a crime against you until the police arrive. It's justified under the specific self-defense laws, and it's certainly justified under the broad justification laws. Our ability to use deadly force, if ourselves or someone else perceives that we are going to receive a substantial bodily injury or that type of threat, the continuum of force raises and we can use deadly force. We are permitted to defend our habitation and use deadly force in certain circumstances. We are permitted to defend our personal property and use reasonable force in those circumstances. These things all work together. For example, if somebody is in my house and they steal something and they run out the door having stolen something of mine, and I go and I chase them down, I don't have the right to use deadly force then. But then if that person pulls out a gun and is going to shoot me, then now we are no longer under 16-3-24. We are under 16-3-21, where I am defending myself against deadly force, which would entitle and enable me to return deadly force. I say all that to explain there's a lot of folks out there that have tried to really oversimplify this stuff. It's pretty complicated, and they all work together. There is a case that I found, Robinson v. State. It's a half-page case, y'all, which is amazing. Half-page case, Robinson v. State, 270 Georgia Appeals 869. It's from 2004. In this case, this is important, and I need y'all to understand this. I don't know what you've heard, and I don't know what people are bringing to you, but you need to understand this. In this case, a guy goes to his house. He's a mailman. He goes to his house, and he goes in his back door, and he encounters a burglar in his house. He tells the burglar to freeze. The burglar then comes and assaults the man, and then the burglar takes off running outside the house. I have had hundreds of emails where people have said, well, if I walk in and I walk up to my house and somebody's, has just committed a sexual assault against my wife, but they're walking away, well, there's no longer a crime being conducted, so I don't have any right to detain them. Okay, I've gotten that scenario, every hypothetical you can imagine. It's not true. This case, the burglar runs out of the house. The mailman, the homeowner, he didn't steal anything. He had nothing of the guy's property. The homeowner runs after the guy and actually jumps into his mail truck, chases the burglar 2 blocks down the road. The burglar turns left and goes into a yard. The mailman stops the mail truck, runs after him, then gets into a fight and actually gets beat up by the burglar. The burglar now takes off and runs and jumps into the mail truck and starts to drive the mail truck. The mailman chases him down, gets in the mail truck. This is an incredible fact pattern. Gets in the mail truck and somehow disengages the car, and now has got the burglar outside the car and uses a, quote, oak branch. I don't know how big it was, but I'm imagining it was big. Uses an oak branch to restrain him until the police showed up. So in this case, the burglar claimed, well, I was defending myself. I was acting in self-defense. Well, the court said, no, you weren't, because what that mailman, that homeowner did, everything that he did was justified. It specifically says 16-3-23, which is defense of your home, and 16-3-24, which is defense of your personal property, the mail truck. Everything that he did was justified under this. And so all of these folks have been getting stirred up and talking about how you can't detain someone. This is the Georgia Court of Appeals saying that that conduct is absolutely permissible. What this bill does is it stops us from being able to chase somebody down if it deals with somebody else's property or a situation where we don't have all the facts. If I pull into my driveway and there is somebody walking out of my neighbor's house with a TV, they very well may be stealing that TV. Maybe they just bought it. I don't know. I have every right to tell them to stop, to put the TV down. I have every right to call the police. If we repeal citizen's arrest, I would not have the right to chase that person down and tackle them and hold them and place them under arrest, okay? Under that same scenario, if I pull in to my driveway and that same guy walks out of my neighbor's house with a TV and I hear my neighbor screaming for help, then now we have a different set of triggering mechanisms. And in defending someone else under 16-3-21, I can use reasonable force, which I submit to this committee would include detaining that person, if need be, for the police driver to figure out what was going on. It's all about the circumstances. The day this passed the House unanimously last week, an hour later, there was this situation at Chick-Fil-A in Midtown where Chick-fil-A was robbed. And immediately, I got 100 emails about, you know, if your bill passes, then you can't stop what happened at Chick-fil-A, and just the robber, armed robber gets to go, okay? A robbery or an armed robbery is a forcible felony, and under 16-3-21, you are allowed to use force. In fact, you can use deadly force to prevent a forcible felony. Anybody who believes that repealing citizen's arrest would stop the situation that happened at the Chick-fil-A in Midtown is blatantly, intentionally not understanding how all these laws work together. And so I present to you the bill. I know there is a lot of misinformation out there, probably more so than anything I've ever been involved with in my career down here. This is the right policy for Georgia. We do not need citizens playing police. We're not trained. In 1863, we didn't have phones. We didn't have police cars. There was a sheriff on a horse, most likely. And if somebody committed a crime, the only way that you were going to be able to bring them to justice was to detain them by a citizen's arrest. We now live in a totally different world. And what I submit to you is that the things that most of the things that we would need to do to defend ourselves as we see as reasonable and fit under the law, we are able to do with the repeal of citizen's arrest. I know that Mr. Skandalakis is here if this committee wants to hear from him, and I'm happy to answer any questions.
Thank you, Leader Reeves. I'll say this, it's as is obvious in your presentation, you know, this is something that I think if you ask any of us, we know where we want to go with this, but it's complicated. And as you've done your presentation, I've given you a hard time in the past in your time in the legislature about how long you speak. That's a joke we have that we still make all the time. But you were able, even with you speaking, you were able to get this down in a concise way that still doesn't really show the work you've done. And so I appreciate you. You've gone through this whole thing. You've read the cases you had to read, the work you've done to get this ready for us, to make sure that we get this right. It'd be easy to go in and just repeal something. That's right. But we got to make sure we get it right. And you've done the work on that. And I just want to say thank you for the work you've done in the past, really for the last year, at least since last summer. I know you've been working directly on this issue. I just want to say that I appreciate you.
And so the committee understands, I read every case on citizens arrest. It's in Georgia case law, and I read a large percentage of the self-defense laws. I felt like to get into this, I couldn't do this, and I couldn't sit in front of a committee like yours unless I understood this more than perhaps anybody understands it in the state at this moment.
Any questions for Leader Reeves at this time? Senator Kirkpatrick.
Thank you, Chairman Reeves, for bringing this to us. I wanted to just ask, as you said, we've all been getting lots of emails and misinformation. One of the things that someone asked or stated is that we would then be the only state without a citizen's arrest law. Have you heard that one?
All 50 states have some form or fashion of a citizen's arrest law, which date back to the 1800s. As a result of what we're doing here, it's my understanding that New York and South Carolina legislators have filed bills to repeal their citizens arrest as well. This is an outdated concept that's not necessary, and what it does is it creates inherently dangerous situations, and we have to value life and property somewhere. And does this mean that sometimes somebody gets away? Yes, it does, but that's a scale of how we value life and property. And I believe that other states will follow our lead in this. I do not believe that Georgia will be lacking for anything by repealing this very outdated, antiquated statute that is destined to lead to tragic results, just like it did of what these murderers in Brunswick claimed that they were using this for. It's not something that is needed in today's world.
Any other questions for the author? Senator Cowsert.
I've been asked to inquire of you on behalf of Senator John Albers, our Public Safety Chairman, if it would be deemed a friendly amendment to include in your provisions for law enforcement officers out of jurisdiction a provision for retired officers that are post-certified to be able to make a detention just like an officer would be. I don't think anybody wants to derail the bill. It's such a delicate balance you've struck, but he just
I guess
wanted me to inquire.
The question that I would have is, would they be prevented from what we're doing here is clarifying if a retired, so it says otherwise, respect to a law enforcement officer's, I guess what I would really need to understand is that is a retired law enforcement officer who still is post-certified still a, quote, law enforcement officer under the eyes of the law, and if there were to be a fact pattern brought before a court on that, again, part of this is trying to patchwork so the court doesn't have to blaze a new trail on some of this stuff, but it potentially could be that a court would find that a retired police officer could exercise that kind of authority or out of jurisdiction activity. I think it's hard for me to answer that right now. I feel like I've got the globe balanced on a pen, and
all right, just think about it. It would be between lines 44 and 47, somewhere in there, to include an additional category in addition to a law enforcement officer, a retired post-certified officer, because if one of those fellows who's trained and understands the use of force and is current on his certifications or whatever you would call that, sees an offense committed in his presence or is assisting local law enforcement or in hot pursuit, so to speak, they might be a force multiplier for our depleted police officers. Now, if you'll just give that some thought.
That's what I would love to do is look at that. I would ask that we not make that amendment now, but that you.
I don't plan to.
Sure, and that I'll be happy to look at that and see kind of where this language gets us with that.
Any other questions for the author? All right, you can sit tight. We have several people signed up to speak on the bill. We'll start with Mr. Ed Stone.
Hi.
Good evening.
First of all, thank you for giving citizens a chance to talk about this bill. I think it's an important bill. It's going to make a drastic change to Georgia's laws. My name is Ed Stone. I'm an attorney. I've been an attorney for 21 years. I was formerly a law enforcement officer. I did that for 12 years, most recently in Union City, which is South Fulton County down by the airport. I have made thousands of arrests. I have multiple times made arrests as a private citizen, and I have to say I sit here seething just a little bit listening to the characterizations of somebody who would do what I view and what the Georgia Supreme Court has viewed and has stated is the duty of a citizen and a good and honorable thing. House Bill 479, I'm strongly opposed. In fact, I think we should call it the Make a Citizen's Arrest a Felony Bill. As Madam Senator pointed out, Georgia will be the only state in the nation, if this bill passes, where one has no way to detain a criminal, no matter how horrible the crime, until the police arrive, even if that's just 2 minutes later. This is bad public policy, and it's bad public policy because it encourages criminals, because it makes escape an easier prospect for them. We heard about Chick-fil-A. The reason people are getting emails about Chick-fil-A is, ironically, that Chick-fil-A robbery at Colony Square happened on the very afternoon that the House passed this bill. And what you're not being told is that force was not used to prevent a forcible felony in that case. The robber stopped the forcible felony on his own. He went outside, and he was chased down by Georgia citizens, one of whom had a firearm. Now, this is important because we're being told that people are blatantly and intentionally not understanding what happened there. But it's blatantly and intentionally misrepresenting what happened. Nobody stopped a forcible felony. Nobody prevented a forcible felony. The statute you just heard quoted was OCGA 16-321. That statute allows one to defend oneself or another, a third person, if you are defending yourself against the imminent use of unlawful force. Imminent is a very important word. It, in plain English, means just about to happen. Something that has already happened, something that the bad actor has stopped doing, and something from which he is fleeing is not imminent because it is not just about to happen. And by taking him into custody and holding him for the police, you are not preventing the forcible felony. You're detaining him because he already committed the forcible felony. Citizens' arrests, by the way, are not unusual. They're very common. When I was a police officer, it was a very common occurrence to take into custody people who'd been arrested under the citizens' arrest statutes. I spoke with Lee Weems, the chief deputy of Oconee County, because it's been a long time since I was a law enforcement officer, and he assured me that that is still a common occurrence, and he estimates it's multiple times daily in the state of Georgia. It is incumbent upon this body to know what the current law is, and especially to know the consequences of any legislation that you vote upon will be upon the law. We heard earlier about the Robinson case. I ask you, please read it. As Representative Reeves has said, it's very short. You can read it for yourself. In that case, the homeowner did make an arrest. It wasn't an issue in the case. As you might guess from the title of the case, Robinson versus the state, the parties to this case are Robinson, he's the burglar, and the state, that's the state of Georgia. The homeowner wasn't a party to this case. The validity of the arrest wasn't an issue in this case because we have a citizen's arrest statute. And as the facts were recited to you, the homeowner actually saw this burglar committing a burglary in his presence. The citizen's arrest statute says you have the right to arrest him. The burglar attacked him and bit him. The burglar was charged, among other things, with battery, which is a violent crime. On appeal, and keep in mind the Georgia Court of Appeals only takes the issues that are appealed. The homeowner wasn't appealing anything. The burglar didn't appeal the validity of his arrest. On appeal, the burglar said the judge should have given that jury a jury instruction on self-defense. I had a right to defend myself from that homeowner. And the Georgia Court of Appeals said, yeah, no, you don't. And that's where they cite these statutes. And they did say the homeowner was acting legally in defending his home and therefore you, sir, are not entitled to a jury instruction under 16-321. There is nothing in that case that says you can go chase down a criminal and arrest them when the unlawful force is no longer imminent. I encourage you to please do your own homework and read those self-defense statutes starting at 16-321, because those are going to tell you what you're voting on. Now, if you're being told those are going to allow you to chase people down and arrest them, then I'd ask, what's the point of this bill? What does it accomplish? We're repealing the citizen's arrest statute, but you're still going to be able to make a citizen's arrest. That logically just doesn't make sense. You will not be able to make a citizen's arrest, and that's because the statutes for citizen's arrest are the legal authority for an arrest. False imprisonment is a statute in this state that is a felony, and it consists of someone who detains a person without legal authority. The legal authority for an arrest comes from the very things that this bill repeals in Section 2, which are OCGA 17-460, OCGA 17-461, and 62. Police officers' powers of arrest, by the way, are in 17-4-20. Those aren't being repealed. But as you know, when a police officer, a city police officer, like I was myself, is outside of his jurisdiction and he makes an arrest, as long as it's consistent with the statutes on a citizen's arrest, the court says, well, police officers are citizens too. And so this is a valid arrest. So this bill, or whoever authored that section of the bill, lines 44 through 51, knew those officers would no longer be able to make a citizen's arrest. But we're being told as a non-police officer, don't worry, you'll be able under the self-defense statutes to go ahead and make one. I've also taken a look at the case law on legal authority for an arrest. And I will tell you that in every case, the courts cite to statutory circumstances, which are 17-460, 61, and 62. In fact, in just a few minutes, I pulled several of those cases and cut and pasted them here. Mr. Chairman, could I pass these out? I've got enough here for everyone.
Yes, we'll have somebody come grab them from you.
Thank you. You'll see at the top of the page the false imprisonment statute, which is important because detaining a person without legal authority, and the legal authority is being repealed by this statute, means 10 years in prison. If you use a firearm like one of the persons did at Chick-Fil-a, that's aggravated assault. That's 20 years in prison. If you move the person, like for example, from your front yard onto the porch to wait for the police, that is an additional element which constitutes kidnapping. That's the only difference between false imprisonment and kidnapping. Asportation, you've moved him no matter how slightly. That's 20 years in prison. And if the criminal is injured during a kidnapping, that's life in prison. So it could very well be that once this bill is passed, the people who do what most of us would view as a good, honorable thing are actually facing more prison time than the criminals that they arrest. I'd like to address one last thing, which is justification, 16-320. And we're being told, well, the justification statute somehow will still cover us and somehow you'll still make an arrest. It still leaves that logical leap here that, you know, we're saying you can't do a citizen's arrest, but somehow we're still going to be able to under 16-320. Under 16-320, number 4 is when the person's conduct is reasonable and is performed in the course of making a lawful arrest. Well, there's a reason that one wasn't being cited to you, because it's no longer going to be a lawful arrest. So we're being told when that number 5 would apply when the person's conduct is justified for any other reason under the laws of this state. There won't be any other reason under the laws of this state. You're repealing those statutes. As you can see from the handouts that just came around, every one of these cases cites to, for police officers, 17-420, or for individuals, 17-460. You can see that under the heading Case Law on the Legal Authority to Detain a Person says the only legal authority is contained in OCGA 17-460, 61, and 62. And that Supreme Court case that says it's the duty of a private citizen to make an arrest is cited directly under that. But the Kroger case is the case in the block quote below that. You'll see in the last line, basically the only justifications for arrest that keep you from being arrested for a crime or sued in tort are 17-420 if you're a police officer, or 17460. There it is in black and white. That is from the Georgia Court of Appeals. And if you continue to page through, you'll see one case after another where they refer to statutory circumstances applicable to law enforcement officers or private persons on the next page. Federal case law also cites to Georgia's citizen arrest statute. Now, that was under the old numbering system, but that is today's 17460. And then, of course, the case at the bottom of the next page is Bacon versus State, which is the reason why lines 44 through 51 are a part of the bill. A municipal officer outside of the city limits could no longer make a citizen's arrest because it won't exist anymore if you pass House Bill 479. And anyway, there's another case there to follow on. I encourage you to please look at those. Number 6 under 16320 is all circumstances which stand upon the same footing of reason and justice as those enumerated in this article. The article is not just that statute, it is the entire justification and self-defense statutes, but I encourage you again, please read them. They are not that complicated. They are not. The word imminent, just grab a dictionary if you don't know it. It means something's just about to happen. It doesn't mean that you can go and make an arrest after it's no longer happening. If I were to threaten, I'm not threatening anybody here, but if I were to threaten a member of this committee with a weapon and you shot me dead in front of all these witnesses, you would have a justification of self-defense. He was threatening me with imminent death or bodily harm, and I exercise self-defense. If, however, you didn't shoot me dead and I just left and you hunted me down in the parking lot and shot me in the back, that is no longer self-defense because it's not imminent. And that is the difference between the footing and circumstances that's referred to in justification for the self-defense statutes and for a citizen's arrest. You'll notice that lines 44 through 51, some of the language for police officers has been stolen directly from the citizen's arrest statute that you are repealing if you pass this bill. And that is because that is the basis for an arrest. It's good public policy, and it's good to let police officers make an arrest that citizens can make, of course, if they're outside of their powers of arrest as a police officer. But it is also a good thing for citizens to do an honorable duty of making a citizen's arrest when they witness a crime. You know, I'll give you an example. When I was a police officer, I pulled up to a store where somebody had pushed a little old lady onto the concrete sidewalk and shattered her hip. This lady's laying there screaming. There were plenty of full-grown men who had witnessed this. They were standing around. They were still there. None of them had grabbed this guy. And I remember thinking to myself, I was disgusted. What a bunch of cowards. You know, they wouldn't even grab this guy for 2 minutes was my response time. This guy got away. To this day, I have no idea who he was. But if you pass House Bill 479, that will be the only acceptable course of conduct, is to allow the person to escape and hope the police get there quicker than 2 minutes, I guess. Because to do otherwise risks 10 years in prison at a minimum. That concludes my comments on it. Please, please, please read the citations that have been given to you. And are there any questions I can resolve while I'm still standing here?
Any questions for Mr. Stone? Senator Parent?
Your name in the beginning.
I'm sorry, my name is Ed, E.D. Stone, S-T-O-N-E.
Thank you. And are you representing yourself, or are you affiliated with any organization?
You might recognize me from an organization I used to come here and speak on behalf of pretty frequently, but I'm no longer in a leadership position with that organization, and I'm not here on behalf of any organization, just myself as a Georgia citizen.
Thank you.
Any other questions for Mr. Stone? Thank you very much.
Thank you for the opportunity to speak.
I'm going to ask the author, if you will, because he raised a lot of points there. If you could brief, I don't ask you all through all these cases. I don't know if you've seen these cases from the House, but I'd like for you to briefly answer the questions, and in particular, a couple scenarios he raised, and also the issue he raised about it if we're repealing citizen's arrest, but we still have citizen's arrest. If you can just give your position on that.
Okay, yeah, obviously I disagree with much of what was just said. Again, this is an example of what I call the extraordinarily narrow reading of these laws, and it doesn't take into account the broadness of the concept of justification. If there is anybody in this room that thinks the old lady example that he described, that if an old lady got her head smashed in, and that if somebody chose to detain that person till the police arrived because of the violence had just been committed, God only knows if violence is going to be committed elsewhere. Is anybody in this room that thinks that that person is going to be arrested when that level of threat was just given to that lady? I don't know what to say, but I want to say this. Let me clear something up. This absolutely does prevent the ability of a civilian, with the exception of the narrow exceptions that we've made. It does prevent a civilian from making a, quote, arrest. But an arrest is not necessarily the same thing as a detention. And a detention can be contemplated under self-defense and under justification. Talking about the Robinson case, the Robinson case doesn't mention citizen's arrest one time. The speaker just now came to us and said that he engaged in a citizen's arrest. Well, that's not in this case. It doesn't say anything about it. But what it does say was that the homeowner's, his conduct was justified under 16.3, 23, and 24. It does say that. And again, I would just ask you to use your common sense. If there's a forcible felony being committed at a Chick-Fil-A in Midtown, and an individual detains a person from continuing the commission of that, and what is an escape, which is a part of the criminal transaction, an escape is part of the criminal transaction, and preventing that escape. If you think that somebody's going to get arrested for preventing someone from escaping from a forcible felony, raise your hands in this room if you think that. I don't have anything else to say.
Thank you, Leader Reeves. We have volume buttons, luckily, for the sound. Appreciate your passion for the issue. Next person out to speak is Thomas Weaver. I give you a hard time.
Thank you, Mr. Chairman, for allowing me to speak on second occasion. In approbation of the remarks that were placed by the governor's floor leader and the other camera, along with the remarks that have been placed by yourself and other members of the committee, and parroting off of some of the thoughts that had kind of ran through my mind as Mr. Stone was placing his testimony to the committee. In order for me to make a more succinct comment, I would have to give a lot of these different things thought. Sometimes in life's journey we find it is better not to speak. This might be one of those occasions. Thank you, and with that, I'll leave it alone.
I appreciate that. We could all probably take a lesson in that some days. Thank you, Mr. Weaver. Next person signed to speak is Pete Skandalakis with the Prosecuting Attorney's Council.
Thank you, Mr. Chairman. And just real briefly, we support House Bill 479, and there's nothing really more I can add to what Leader Reeves has said. We don't think cases occur in a vacuum. We do think the statutes he has cited, justification, self-defense, defensive habitation, would cover most of those instances. And we support 479 as it is, and I'll answer any questions if you have any questions.
Any questions for Mr. Skandalakis? No questions. Thank you.
Thank you, sir.
We have James Woodall, the state president of the Georgia NAACP.
Thank you, Mr. Chairman, and to members of the committee. I want to just briefly go through 4 particular problems that arise in the current statute as is, and then talk primarily about what the new bill would present as a resolution. Because one, the reality is we're here not because of speculation on what could happen or things that possibly could happen, but we're here because there are thousands upon thousands of Georgians who have been murdered here in this state using this statute as justification. And not conspiracy, not speculation, but there has been documented evidence that people have been murdered, lynched, and not just Ahmaud Arbery, Kenneth Herring in Clayton County, just 2 years prior, was also murdered and justifiably was justified using this code. So 4 particular problems arise related to this circumstance in which an arrest by a citizen or private citizen can be made. One would be that the term within his immediate knowledge would authorize an individual to determine whether an offense has been committed through information not derived from their own person, but by other third-party information. Secondly, citizens' arrest of suspected felons as opposed to misdemeanors may take place before, during, or after the commission of that crime. Further, a private person does not need to be present when that crime is committed to be able to conduct and apprehend a suspected felon. Third, the Georgia Citizens Arrest Statute fails to distinguish between felonies that are immediate threats to public welfare and those that do not constitute a continuing immediate threat. That's currently in law today. Fourth, 17-4-60 establishes that a private person may arrest him upon reasonable and probable grounds of suspicion, seemingly only apply to felonies. Those reasonable and probable cause provisions is problematic because quite honestly, everyday citizens don't know the evidentiary thresholds that are constituted in this statute. And so when we talk about, police officers retired, those kind of things, they are trained to do those kind of things, but everyday citizens are not. And so I want to conclude by just saying that Section 2 is a complete repeal, meaning that no private citizen will be able to make an arrest. As the leader has shared, there are detentions that are able to be made in this proposed legislation. And then 2, self-defense as relates to reasonable use of force. Currently right now in code, there is no guidance as to what threshold of force can be used under the law currently. And so this is attempting to clarify language, and we believe that this is good public policy. There has been a comprehensive approach and evaluation of all parties involved, and we as a Georgia NAACP support this legislation wholeheartedly.
Thank you, Mr. Woodall. Any questions for him? Thank you very much. Next, we have Cosby Johnson, the Vice President of the Georgia Chamber of Commerce.
Mr. Chairman, thank you so much. This is my first time before your committee, so thank you all for having me. Also, it's great to go after President Woodall, and we are glad to finally get him in a lobbyist blazer. So we were good to wrap him up, and I want to say thank you to Chairman Reeves for all of his amazing work on this and working beside him. I know he has worked hard. He's going through all of the statutes to figure out the best way to move forward on this. And I would also like to thank the governor for his leadership. I'm here representing the Georgia Chamber of Commerce, but I will be fairly brief because I'm also a son of Brunswick, Georgia, was born and raised in Brunswick, Georgia, which is the city where Ahmaud Arbery was murdered. It is extremely important, not only to my family and those in my community, but also those who seek to live in a Georgia where they don't have to worry about these things anymore, and they don't have to worry about a citizen not with the training of Mr. Stone chasing them down in a neighborhood and murdering them and using this antiquated law as justification to do that. We thank you for you all's leadership and pushing Georgia forward to think about this in a smart way and to do it the right way. And with that, I will yield for any questions, and I thank you for your time.
Any questions for Mr. Johnson? Thank you very much. We have Chris Bruce with the ACLU of Georgia, our final speaker.
Yes, thank you, Mr. Chairman and members of the committee. Christopher Bruce, Political Director for the ACLU of Georgia. I have left my laptop at the desk because I'm going to be brief because I know the hour is 9. And I also want to say Chairman Reeves has done a great and excellent job doing the research thoroughly. And as a proud graduate of Georgia Law School, the finest law school in the nation, I can honestly follow every argument that he has put forth. I know it's still the finest, yes, that he has put forth in the policy that's put together. You have the political director of the ACLU of Georgia saying, trust the police when it comes to making an arrest. Okay? And that's why we fully support this bill at this time. The research has been done. We trust the process, and we fully support this bill altogether. We do always have concerns, and it's been a bipartisan concern about reporting, and that's one of the reasons why we do have issues with actually getting the information that goes with citizen arrest. This has nothing to do with that. What we do want to point out, though, is again, this bill is a step forward into justification of the safety of all Georgians. So thank you for your time, Mr. Chairman, and I yield for any questions.
Any questions for Mr. Bruce? Thank you so much.
Thank you.
There's no one else assigned to be heard on the bill. What's the pleasure of the committee?
Move to pass.
We have a motion to pass by Senator Calzert. We have a second. We have a second by Senator Parent. Any discussion? All those in favor of the motion, please raise your hand. It passed unanimously.
Thank you, committee. Thank you.
All right, thank you. Who's going to carry this in the Senate?
Senator Calzert.
Senator Calzert. Thank you, Leader Reeves. All right, we have one measure left on the agenda. It's on for hearing only. And as y'all probably noticed, you can come on up, Representative Gaines. We don't have the ability to really do any subcommittees after crossover because of scheduling. We try to do scheduling. It's just as hard to schedule a full committee with everybody's schedule. And so I'm trying to put some of these bills on for hearing only just to give us a chance to get introduced to the bill so we can hopefully get to more stuff next week in our final two hearings. And so with that, I'll turn it over to you, Representative Gaines. Let me get you your mic on. Okay. All right, you're good.
Thank you, Mr. Chairman, and appreciate the committee. I'll try to be brief and feel really like this is an important measure that we brought before you, House Bill 231, and we should be looking at LC 413102S. And what this legislation does is it closes a gap in current Georgia law to extend temporary protective order life.
Can I cut you off for 1 second? There was the LC he mentioned, 3102S, is being passed around. Just got passed around.
Perfect.
So there's two in your folder, but look at 3102S. All right,
perfect. Thank you. And I'll walk through what the differences are between that and what bill you would have had in your original folder after I briefly just kind of give the highlights of what this legislation does. But what this bill does is it extends life-saving protection to victims of dating violence. It's frankly a gap in current Georgia law. We're one of only 3 states that do not provide this sort of protection for victims of dating violence. It also would include victims of violence who are currently have a pregnancy with another individual. And so what this bill does is does provide that the opportunity for those individuals who are victims to seek temporary protective orders. And what we've done in the House is we spent a lot of time in committee on this bill, significant amount of time. Initially, this was under we essentially just added this to the family violence statute. We ultimately brought this out into its own dating violence protective order and tightened up the language a bit to make sure we had addressed any concerns that had been brought forward. And so feel like we've worked this language significantly and found a way to make sure we're protecting victims while also addressing any concerns. Have Solicitor Rebecca Greist with us from Macon-Bibb County, who's worked with us quite a bit on this language. There's a lot of other advocates who've helped us as well along the process. But, again, feel like this is an important step forward for, in our fight against domestic violence in Georgia. States that have done this proactively have seen 11% reduction in intimate partner homicide, and I could give you a lot of other statistics, but I'll briefly walk through the changes from the House version just so you know what the differences are. There's essentially 5 changes. The first one being on lines, I guess in the substitutes on lines 13, there was some unnecessary language, just some cleanup that we took out from the that doesn't apply because since we took it out of the family violence statute, so that's what that change is. Again, just clean up there. On line 33, and that was on the original bill. So on this bill, it's line 32 where we added the word recently. for recently dating relationship. That's something that, in talking to the folks who, the advocates and folks who really work in this, on this issue, that's one of the most vulnerable times for victims is right after a breakup, and so that's something we felt was important to add. On line 34, there was a couple of offenses that are not currently in Georgia law, and then a couple that were felonies already, and we added language on 33 to include any felony, and then so we just cleaned up that language on line 34, and then on line 50, actually line 48 in the sub. This would allow for individuals 16 and 17 to be able to seek some relief as well. And that's something that I think, between now and the next committee meeting, that's probably something we need to continue to talk through, and whether that's something we can address this year, that's something we need to look at moving forward. Obviously, as we talk to advocates, again, 16 and 17 years old, those are years where individuals are significantly at risk of violence as victims. And then on line 90, and in the sub, that would be line 87, and changing an and to an or. And again, something the advocates felt was an important change. So those are the changes from the House version. And Solicitor, I don't know if there's anything additionally you'd like to add, but I'm happy to walk through the bill more in depth if you'd like us to, or just happy to answer any questions.
And we do have Rebecca Greist here, the Solicitor General in Bibb County, that you mentioned. And before we do that, before we have you speak, I do have a question for you, Senator Hatchett.
Yeah, thank you, and thank you, Mr. Chairman. Thank you for bringing this piece of legislation. I've got a quick question. As a father of 2, soon to be 3 little girls, this is something that's important to me to make sure they can be protected. My question is this only, and I've been trying to flip through the bill, does this only apply to dating relationships, or does this apply to, if my daughter's 16 years old and somebody decides to, hopefully this never happens, but does try to assault her in some way and isn't necessarily stalking, could at that point, would this, could I apply for a TPO, or could she apply for a TPO in that circumstance?
Okay, it would depend on the nature of the relationship, because one thing that really came out in committee on the House side of things is this concern that we didn't want to have people who were in a casual relationship or buddies who were neighbors, that kind of thing. So it really would completely depend on what the nature of the relationship was. It may be that you might seek a different vehicle, which might be a temporary restraining order in a civil arena, but you'd have to go and get an attorney for that type of thing. It's a different standard, it's a different process. So it would depend on the nature of the relationship. And what we're trying to address here is there's a huge gap between the people who can get a protective order because they are in a family violence relationship under the laws of the state of Georgia. They have a child together. They live in the same household. They ever lived in the same house. They're divorced, that type of thing. Well, that covers a lot of people, but what that does not cover is people who were in relationships in high school and college. And again, statistically, the worst time for violence in these in relationships is between the age of 16 and 24. And so that is what we're really trying to reach, to try to prevent these situations from getting any worse. And another thing that came up is you also have people who are divorced or they're widowed or something like that. Well, they're not necessarily going to want to move into the same house with their boyfriend because that's a much more complicated scenario. And so you've got college age kids, you've got young people who aren't pregnant yet, thank goodness, and who aren't, moving in together. And that does not change the nature of the manipulation that can occur in a relationship or anything of that nature. And so that's really what we're trying to get to. And I understand that there have been concerns about the recency of a relationship. I think nobody wants to see that, you reach out to your high school girlfriend on Facebook to be friends and suddenly you end up with a protective order against you. That's not what we're contemplating here. And that's kind of why we have tailored the language to, recent relationship, because you do need to absolutely encompass that time period, because the most dangerous time for a person getting out of a relationship is when they're breaking up, because passions are so high at that point. Let's see, and I think that was all I had on that.
Thank you.
As far as the world of TPOs, we've had other bills this session dealing with this, and everybody's familiar with how they work. So you have the TPO you can get in a stalking situation.
Yes.
You have a TPO in a family violence situation.
Yes.
And then you would be adding a third category, in essence, for the dating scenario.
That is
a simple way of looking at it? And the process for obtaining the TPO, as far as the procedure of that, the way you did your bill, is it tracked procedurally the same way we deal with TPOs for family violence and stalking?
Yes, it does. And the big difference there is the way that the stalking protective order statute is set up, as well as the family violence protective order. It really uses the ability of the local resource centers like Crisis Line and Safe Houses, ours in Middle Georgia. And, they have advocates who, number one, screen through these petitions for protective orders before they ever bring it in front of a judge. And that is, a good thing on many accounts, because you're not wasting the judge's time. These advocates are not going to waste their credibility with their judge on something they know they cannot get a protective order on. And so, that is allowed for by statute. Whereas if there wasn't a relationship, if you're just, I need to get a restraining order against my neighbor, there are a lot more hoops that you have to jump through in order to get that. And so we want to keep it as easy and accessible to different types of victims as we possibly can, because you are preventing murders here. I mean, that's what a lot of times people don't realize, is that misdemeanor prosecution and advocacy work like this can be preventing murders.
Right.
Sometimes it doesn't.
Senator Kirkpatrick has a question.
Yes, ma'am.
Yes, I do. The current family violence protective order and the stalking protective order,
yes,
do those apply to minors?
Yes, they do. And we do it through the, they do, through the, you could have an adult apply for a minor. But it would be, okay, and I should say you would have to have an adult defendant. Do you know what I'm saying? Like that person would have to be over the age of 18 years old to be a party to a civil action. But a lot of times what you'll have is a 16-year-old girlfriend and an 18-year-old boyfriend, or vice versa. And so the 16-year-old has to have a parent stand in their place to create that action.
Okay, I would just think it needs to match.
Yes,
between the statutes.
and honestly, the reason why it doesn't match completely is because we were trying to address some concerns of Chairman Burchett in drafting this. So
that that was honestly one of the conversations that we had a significant amount of time around is the minor piece, and that's something we tried to again. And this substitute is try to find some sort of compromise language to make sure we're still, I guess making sure we're following the spirit of what we did in the House. But that is something that, we spent a lot of time around, and there were concerns about including minors. And so we feel like that 16 language is something we could look at. We also understand that, I think the bill as a whole is really important that we get something done this year. And so even if we, are at 18, and that's something we look at in the future, that's something we've talked about as well.
Yeah.
And just one follow-up on that, the way you drafted it, is it match the way an adult would file on behalf of a minor in a family violence or stalking situation?
For the 16 and 17-year-olds, but anybody under 16, how it's drafted now, would not be able to to seek one.
And again, I think that was also for us. The concern was, okay, if my 11-year-old has a little girlfriend at school and they hold hands, does that make him suddenly where he's going to have to have he's going to be subject to a protective order? And so what we were trying to do, we understand that. So I think our kind of compromise we're presenting here is, okay, let's please address these 16 and 17-year-olds, because a 16 is, the age of consent. And so they are treated already differently under the law than a person under the age of 16. That's why.
That makes sense to me.
Yeah, that's the why.
I understand now. Any other questions for the author or Ms. Grice? I believe, Mr. Weaver, do you want to be heard on this bill? Yeah, want to step up? Y'all can stay in your seat.
Mr. Chairman, members of the committee, thank you for recognizing me to speak on third and last occasion this evening. I'll be incredibly very brief. I had a concern initially with the former version of the bill that was passed through the House. The Representative Gaines was very, very generous to meet with me for a few minutes so that my concern could be addressed. However, to the extent that this is a new substitute version and has just been recently given to each of you immediately prior to the meeting, I haven't had a chance to look at the new substitute version. If the chair would be gracious enough to allow it, and if this committee should approve of it, could I just please see a copy of the substitute version?
If we have an extra copy, we'll give it to you now. And that's one of the other reasons that some of these bills are hearing only, so everybody can have a chance to look at that. And obviously, you'll get a chance, Mr. Weaver, to speak at the next hearing if you like to make comments after you look at that too.
Just a moment, please, Mr.
Yes, sir.
Chairman, while I look.
And while you're looking at it, I encourage, this, but the committee members, if you look at these bills, especially the ones that are hearing only, and have comments or things you want to see on the bill, it's a good chance to go see the author prior to next week. The good news is this will be our last late night hearing. That somewhere Jesse's just like rolling his eyes at me right now. I'm sure he's watching. But we have next week on Monday at 2:15 our usual time, but Wednesday is a committee day. And your chairman got ahead of everybody else and requested the 8 o'clock time slot in the morning next Wednesday. Down says you got to be here at 8 o'clock, but we'll have a little more time to wrap up our business, and we will not be here in the afternoon on Wednesday. So if it makes anybody feel better about tonight.
Again, Mr. Chairman, I'll be very, very brief.
Yes,
I
sir.
know that everyone wants to get home. I'm grateful that Representative Gaines did, in fact, address my concern on lines 33 and 34 of the bill. I had raised the issue regarding a separate legislative measure that he was carrying through the House, and the concern about aligning what offenses will put you into this have been addressed. However, based on what I had learned and listening attentively to what the Solicitor General from Macon-Bibb had shared, is the committee desirous, I suppose from a public policy question, to define, based on statute, the term recently, such that it wouldn't be subject to judicial discretion? Would one judge be inclined to say recently meant a month ago, and then another judge in some other judicial circuit, because this would, I would assume this would be in the Superior Court if it's trending off of what's already law under Chapter 13. Would another Superior Court judge in a different judicial circuit would say, well, at any point during the grade year, especially when you're contemplating those whom are of age of consent and still in high school? Or would another judge in a different judicial circuit say, well, recently means during the last calendar year, even though there's been, so I don't know if that's something that the committee would want to consider also. And then the second thing, and this is just off the top of my mind, under line 34, I do think it's important to point out that under Chapter 13 of Title 19 of the Official Code of Georgia, annotated prescribing for the crime of family violence, it includes criminal trespass. This one does not. Not saying that you would want criminal trespass in here or not. I'm just wanting just an approbation of the concern that I had raised to Representative Gaines as to what you want to include and what not. That would put you into this.
All right. Thank you, Mr. Weaver. Any questions for Mr. Weaver? I think Senator Kennedy had a comment.
Just briefly, thank you, Mr. Chairman. I want to thank Representative Gaines for bringing this, and also say hello to my friend and our solicitor from Bibb County that I'm very proud to serve with. She's been a tireless advocate for victims, and she's been at the Capitol many times over the past few years, and I appreciate you being here with this, and thanks for serving our folks in our district.
It is my pleasure.
Yeah, my first time getting to see you as chair of the committee, so I'm glad you got to come back this session.
I know, this is great.
Good to get to see you. Any final questions, members of the committee? All right, well, thank you all for staying so late.
Thank you very much.
Yeah, thank you, and we are adjourned.